Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5231. California Valley Miwok Tribe et al. Appellants versus Douglas Burgum, U.S. Secretary of the Interior et al. Ms. Walker for the appellants, Ms. Bray for the appellants.
Please, the court.
Morning.
Morning. CVMT seeks reversal of the 2024 District Court COP decision for two primary reasons. First, the lower court did not follow the remand, what we refer to as CVM3 decision, the remand decision that found ASIA Echohawk's decision unreasonable and allowed for the reorganization of the tribe. And two, claims ASIA Newland's decision failed to protect the tribe's political integrity when it allowed a 1929 Indian census of all Calaveras Miwoks to establish the tribe's membership criteria. Felix Cohen, a scholar of federal Indian sovereignty law, wrote, "Courts have consistently recognized that one of the Indian tribe's most basic powers is the authority to determine questions of its own membership. A tribe's right to define its own membership for tribal purposes has long been recognized central to its existence."
I don't quite understand how that squares with the litigation position of your clients when there were other tribal members trying to exclude them from the group that would write the Constitution for this tribe.
Got it. There's a long history in this case, but our position is the 1915 descendants, which is about 11 people, they stood for, when they were fighting the Sylvia Burley faction, that they had a larger community. They had developed a community of folks and had identified them. So it was a misinterpretation of Judge Cobb that the descendants wanted to create this very small tribe. No, they stood in the earlier cases for her faction of 3 or 4 people was not the tribe, that they wanted to go back to the historical community and they had identified them.
I understand that, but if what you just led with were the rule, then those 3 or 4 people who wanted to define the tribe would have been able to exclude your clients when your clients were on the outs, as you just said they once were.
Tribal enrollment's not easy to understand, but I've created some tribal enrollment ordinances and I kind of know how it works. And basically, it's not off of one particular role. Federal or state census rolls are just inherently an error. It's up to the tribe to look at what they consider a base role of the community. And sometimes that includes direct line lineal descendants, and sometimes it includes collateral descendants. This is where I think the Cobb Court got confused, and it is confusing. Because when you start to look at a collateral descendant, for example, I'll just use another tribe, but the Nansemond in Virginia were founded on the Bass family, and they had like 7 children, and 4 of those brothers went off to North Carolina and established other tribes. Are they direct line lineal descendants of a base family role? Yeah, but the other collateral members that left and went to other tribes are not part of the group.
I guess my question is a little bit kind of a step 1 question. And step 2. You're going to the question of who should or should not be in this tribe or in the group that writes the Constitution for this tribe. But my question is, before that, my question is, does the government have a role in saying this group is too small a group to write the Constitution that will define membership in the tribe? And you seem to start your argument today by saying, no, the government doesn't have a role. That's something special for only tribes to do. But if that had been the rule, then
Yeah, I see what you're saying.
Your clients would have lost their earlier lawsuits.
No.
I mean, there has to be a baseline somewhere, and the government is called on to set it. So either, there's federal involvement either way. If we vacate the Newland decision, if we affirm, there's court involvement and there's federal involvement.
Yeah, I know. I'd like to make the distinction. All right. With the organization process, where the federal government was charged after the what we call CVMT3 to form an organizational process, Mr. Washburn, who's quite a scholar and had just recently revised the 2015 revisions to the federal acknowledgement rules, he defined what the government had identified as historical members of the tribe. He wrote in his decision that if those initial members, which could include some members off the 1929 census, but he knew that that census was too broad. So he was allowing the initial historical members to decide who could be the initial putative group, the families that had been connected to that community. That is what they stood for, and they had it in their affidavits that they had a community around Sheep Ranch. So it was a misunderstanding that the court below thought that they were only talking about, only had to be them. It didn't have to be them. They identified other families. And that's why I'm saying in most every tribe, there are direct descendants they know of, and there's family groups that have been maybe a collateral relatives that have been in. Now, I just want to go through the numbers on these census.
Go back though.
Sure.
Before you do that, I just wanted to make this distinction. The BIA looks to constitutional issues, election issues, and supposedly should draw that line of demarcation in that governance piece. But then when you come over to the tribe and potentially tribal courts, that's when they determine who should be the membership and the citizenship. And I look at this as kind of an election boards where if the local legislator says, oh, we need a certain type of ID for voter registration, then that's what they can look at and say, you've either met that or not. But they don't generally go behind it to see if that actual membership was legal or not. I mean, the registration was legal or not in terms of your ID. Is that correct?
Well, elections, generally when tribes are enrolled in a tribe, they get a federal ID that we're a member of the tribe. And not all tribes, the federal government has the authority to come in and do a secretarial election. Most tribes now have done away with that, having the government come in and certify an election. So what I'm
what I'm really getting at is that BIA should be governance. The tribe should be looking at its actual membership, citizenship.
Yeah.
And I feel like in this decision, then what we're grappling with is that under the Washburn decision, there was some misinformation with respect to the whole Jeff Davis, John Jeff descendant piece. Newland then goes ahead and revises the decision to go back and include all of that. But I'm not sure if when you're asking that the Newland decision get reversed, are you asking us to accept the Washburn decision, which had kind of some misinformation about the genealogy piece to Jeff Davis and John Jeff?
Judge Childs, I want to address the misinformation. Kevin Washburn and his decision had attachments that he reviewed. He reviewed the Burley deposition, and he reviewed an important attachment that was left out of the administrative record by the government. That's what we call attachment L. In the new appendix, they agreed to include it. Attachment L, Washburn had, which was Director Riesling, had reviewed this early constitution when they were trying to organize the tribe. And he got a solicitor's opinion back that said the 1929 census was too general to be legally sufficient criteria for membership. And he wrote that back and said, this constitution is not going to fly. Kevin Washburn had that. Also, he had the deposition of Sylvia Burley where she was claiming to be a Jeff. And she wasn't saying she was, but she was lobbying very hard that the Jeffs should be part of these eligible groups. Where the failing was by the Department of Interior was their due diligence to do the genealogy, which was not hard to find, that John Jeff was not the son of Jeff Davis. And so if they had done that, that would have been where you go. So now I just want to say, I know it sounds like unfair to people to go and let one group or another decide membership criteria, but there's a process, and the court articulated it on the remand. It said they had to identify whether the tribal, the group represents members of the tribe, and before invoking the principle of self-government, it's incumbent on first to determine where a duly constituted government actually exists. So you have to go to historical documents identifying who is historical to get that. And then the secretary must ensure that they deal with the tribal government that actually represents members of a tribe applying the trust obligations. So there's a point where the BIA is facilitating the organization and facilitating an initial group that would sit down with the genealogy and with the history and determine, and it could be the initial putative group, people that they know are families connected to Sheep Ranch with the historical connection, to then set membership criteria and then move forward with a constitution. That's the step that got confused.
What criteria would you use to differentiate Miwoks who deserve membership from those who do not?
Yeah, well, what I'd have to be speaking for them, but from everything I've read, it comes down to this. Calaveras County is a large county, 1,000 acres. And there were Miwoks in all different parts of that county. And the ones around this mining town called Sheep Ranch, there was a group of families that lived there and still around that area. And they know each other. And there's a history there. And so they know it. And that's what you would base it on. You'd base it on history, not whether you appeared on a 1929 census. And the numbers are, I'll just give it to you quick. In 1915, they identified 13. In 1927, they identified 25 members of the Sheep Ranch Rancheria. And then in 1929, they did a Calaveras County census of all the Indians in Calaveras County. That was 147. 137 were Miwoks. You minus out those 25 that they identified 2 years earlier as Sheep Ranch Indians, and you got 100 Miwoks that they identified that didn't have the historical connection to that rancheria.
I'm having trouble still distinguishing between your position on what would be appropriate for your clients to write into a constitution about who belongs and the people who even sit down to make those determinations.
I know.
And it would still be open if under the Newland decision, it is still open to all the people who are invited to the table to frame the Constitution to say, we've gone off, we have other tribes, 25 are really the ones that we all understand have this connection.
That's not what happened.
But it hasn't happened yet.
Well, what happened when this group challenged the secretarial election, it was because they were so overshadowed by the people that came in all claiming to be related to John Jeff, that their opinion wasn't heard. And that's why they challenged the secretarial election and they won. And that's when the superintendent, Amy Dutschke, came back and said, sorry, we got to go back to the Washburn. 3 years later, that's when the whole thing was. Now look, in the Jeff family, and boy, you can get lost in Jeffs, and there's a lot of Jeffs in the Miwok community in all of California. The John Jeff and Tilly Jeff had 9 children, and they were in West Point, and they were in the CCO, if I say it right. And that's where they lived, and that's where they're buried. And some of their children had offspring that ended up around the Sheep Ranch community. Maple Hodge was one of their grandchildren, and she married a Hodge, and that's how she ended up in that community. So there were some that migrated into that community, but not all 9 children did.
I guess I'm not understanding.
Yeah, just because you're
answering my question, which is, why doesn't it make sense to have an overbroad group of people, of potential
Yeah.
ultimate members be part of the group that's discussing
Yeah,
that.
because you have people that want to be a member as opposed to people that have the historical connection to be a member. And if you have more of those people that want to be a member than ones that have the historical connection, the people with the history connection get wiped out. And that's what
There's no
happened.
review of that. Tell me, you contend repeatedly in your brief that the Newland decision violated the district court's remand decision in the CVMT 3. Why do you think that? What is it that violates the remand?
Specifically he said, first you have to establish a tribe existed. In the federal acknowledgement process, that would be looking at around the turn of the century and back, was there a historic tribe that continued to exist? This had been identified in some early 1915 census, 1906. There was an 1827 identifying Miwoks around that mining town. So you have that early identification. And
But aren't there multiple Miwok tribes?
Right.
And we're supposed to be distinguishing, for this purpose, the California tribe.
Right. But there's in that county, there were multiple, over that 100 years, multiple Miwok communities, and we're trying to identify the ones of the history to Sheep Ranch. So what I'm saying is, you think about the Great Sioux Nation. Great Sioux Nation, 6 chiefs, they split up, and they all have different tribes with inner relations. But you can't be a member of just any Sioux tribe. You have to go to the history of that tribe. That's what we're saying here. And I've done it. And I know if we were trying.
I understand from what you just said that you think the group that will write the Constitution should be limited to those with a connection to Sheep Ranch. Did I hear that correctly?
Yeah.
Okay. Is that group any bigger than the 1915 census descendants?
Yes. And
okay.
That's identified in the affidavits that were submitted, and they're part of this record of people that the group I work with.
Is that group bigger than the 27 census? Not the 29, but the 27. You seem to like the 27.
Well, no. Well, the 1915, what I'm saying is the modern descendants of 1915, basically that 25 that were identified in 1927 were off those same families. But it didn't turn into 147 2 years later.
So the descendants of the 1927 census, is that a smaller group than people who are descendants from American Indians with a connection to Sheep Ranch?
No. No, there's more. There's, as time moves on, you trace the families that connected into Sheep Ranch as part of the community.
But there's also, in the Newland decision, one of the observations is that the 1915 descendants actually were no longer there since 1940, and descendants of the 1929 census were there and had the connection. So there's a question also of the time for the historical inquiry. And you're insisting on a time, understandably, that includes your clients and doesn't include a large number of other people whose views might outweigh. But what is the principle on which you rest that choice? You say it's the connection to Sheep Ranch, but that connection's been lost for 80 years, no?
No. The Hodges, that family, and other families collateral to the Hodges that were known to have been involved in that community over 75 more years. Let's take Sylvia Burley. We're not trying to case on her, but the reason this controversy came up was she didn't connect in to Sheep Ranch until 1998. And I have the list of places she lived since she was born, and none of them were at Sheep Ranch, and she wasn't connected in. And so and she defrauded them. She disenrolled Yakima and ran off with the money. So that's what they're fearing is.
Did Mabel Dixie have a connection to Sheep Ranch?
Did who?
Mabel Dixie?
Yeah, she lived at Sheep Ranch. She was living there. She lived.
would her heirs be in the group that you think should be the group?
Yeah, but her last heir died. That was Yakima Dixie. That he
How
lived
big-
there after.
How big was the
Not her
sheep?
heirs, I meant her descendants.
Mhm.
Sorry. Yes.
Sorry,
Your
go
Honor.
ahead, Judge Childs. I'll come back to mine.
No, that's okay. Go ahead. Finish your thought.
Well, would Mabel Dixie's descendants, or the descendants of her heirs, would they be in the group that you think should write the Constitution?
Well, Yakima Dixie was her son. She had 4 children. Her last son that died. She was Maple Hodge Dixie. She married the son of John Hodge, Joe Hodge, and John Hodge was the brother of Patterson Hodge, which was on the 1915 list. But his brother, John, died in 1913. So he wasn't on the 1915 list. But she married into that Hodge family, that Hodge community.
Did Mabel Dixie have any heirs at the time she died? No heirs at the time she died?
No.
And no descendants at the time?
No, she had Yakima, I'm sorry. Yakima was alive and he lived at the thing, yeah.
Okay, and then
He did not, no.
Yakima had no descendants?
No. But she goes back to the Hodge line.
Okay.
And how big was the sheep rancheria in 1915? I guess I'm trying to get to the point that it seems like there can't be many people on the land and that some of these tribes will start very small.
Yeah, it was 2 acres. And it remained 2 acres in these different reports, the Kelsey report, the Lips-Michael report, all the way up until the 1960, when it was identified as 0.9 acres. Government sort of misrepresents that because they say it was always 0.9. No, it was identified as 2 acres. What they believe happened is Lena Hodge, that line, was living on one part, and there was some folks on another small shack. These were like just 1-bedroom places.
And are you saying that Washburn in his decision reviewed and decided not to include the 1929 census because it was too broad?
Yes, because it was not, you have to have specific membership criteria, not general. And the solicitor's office had given an opinion to Dale Riesling, the regional director, that it wasn't legally sufficient because
I still don't understand your specific membership criteria.
Yeah.
Though. You said earlier in answer to my question, sort of, maybe the people who are out there will know it when they see it, but
No.
what is the specific?
No,
criteria?
when you get into history, you see families, and some of them, like Maple Hodge Dixie, was a collateral relative in a way because her descendancy up through the Hodge line did not appear on the 1915 census, but she was connected. So what you see is people that are identified in those affidavits that came and lived there, or were part of that Miwok community, and they participated in it. So, and there's history there. It's not that old where they go back and they know what families were part of that sheep ranch community. Indian people are about that. They're about family. They're about community. And
But
just
who should decide about these citizenship questions? Is that the tribe itself, or does this go to a tribal court? We're getting so into the weeds literally of the land. I'm just trying to figure out, should BIA be making these types of determinations, or is that for the tribe itself?
That's what we're here to stand for, is that, like Felix Cohen, it's the Martinez case, is that only a tribe, only someone with the historic connection. So Kevin Washburn, who knew well how tribes get their federal acknowledgement, and he knew well this process is, I know it sounds nebulous, but they start with a roll, and they try to go as early at the turn of the century. Rolls that come in after World War I and II aren't considered as reliable because everybody spreads around after the World Wars. But those early censuses identify an historic tribe. And then from there, you look at the community that built around that historic tribe. And there's history to that. But that's not for the BIA to wave a wand and say, this is your history. That's a no-no.
But you do think it was for Washburn to wave around and say
no,
that was your
Washburn was
history.
BIA. He was a representative. You're just saying you think the substance of his decision was more in keeping with what the tribes would have decided had they been empowered to so decide without any BIA involvement. But either way, there is federal involvement. And so your argument that this is about who decides, it just seems to me neither here nor there, because either way,
Yeah.
it's the same institution.
I know, but this
Then
is a
decide-
big distinction in federal Indian law because of Indian sovereignty, and it's hard to
But-
grasp.
The BIA is involved in the
Yeah.
exact same way with different
Right.
substantive reasoning, whether we rule that the Newland decision survives review or whether we rule that it doesn't and default back to Washburn. So I'm just not following
I know.
the
Well,
arguments that the Fed should stay out of it. I understand that as an historical, as an institutional perspective, but I don't think that is a choice before this court.
Yeah. What Washburn was doing was the process, and that's why I was quoting from the remand decision about how they identified a process. And an organization of a tribe process is different than when you declare them federally recognized. This tribe was already identified as a federal community, and the BIA was on our side fighting the faction that was defrauding the tribe. They were definitely supporting us. I was one of the people that went and we had the BIA funds withheld and the trust funds because she had run off with it and disenrolled Yakima. So the point
Can
of
you
this,
explain then how the IRA works here? I'm thinking that we need to start back with that
Right.
intent.
right, the IRA defines what is a member, and it says a member, and this is in the organizational process, is it has to be a member that's enrolled pursuant to tribal criteria established by the tribe. So what we're talking about here, here's splitting the hair, is you have Kevin Washburn was identifying who was part of a historic community. And then those people part of the historic community can add the people they had on affidavits that they said were collateral relatives that were part of that Miwok community to sit down among themselves and decide, the historic criteria for membership. And then once they get those criteria, they can then enroll the future membership to vote on a constitution. That's how it works. So he was not crossing, I know this sounds vague, but he was not crossing the line of the BIA comes in and tells the tribe, this is the role you use to establish membership. This is the criteria you use to establish membership. He clearly said that is to be left to the tribe, not the government. So there's a role, the BIA had a role in verifying that genealogy. You bet they did. They didn't do their due diligence, and that messed this whole thing up.
Okay, so
And
why is your desire to revive the Washburn decision?
it's not revive it, is what stands, because it was the
And in saying that it stands, it had in there, when we go back to the genealogy piece, that was later error in its assumption about the descendants of Jeff Davis and the John Jeff matter. So do you take that to mean that all of that swath of people would be in, or do you take that to mean that because there was an error that we left with only Jeff Davis, who was the only person in the 1935 IRA voters list for the ranch area?
I've been trying to say the opposite. I'm trying to say the opposite. The court thought that that's what our group stood for, was we didn't like the 5 with Burley and we're the 5 or whatever. It's not about that. It's about they were the historic descendants that then can look at who would be the other collateral members. Tribes are made up of members that might have direct line descendancy or members that have been so connected to the community, they're collateral descendants. They have these interrelations. That's almost in every tribal community. So they sit down and then they decide what is the base role we want to use and what's the criteria for membership. And that's a big distinction. It's not the government's place. And again, our group stood up to the last secretarial election because their view wasn't being considered at all. The people that wanted to be part of that tribe were dominating, not the people that had the connection.
Okay, be real clear about your remedy. Are you asking reversal of summary judgment, vacating of a particular order, things like that?
Yeah, what we are asking for is that now that there is some genealogy that's verified about that, then it's about people coming forth to decide who we call them putative group, because even the descendants aren't members yet. They're part of an organizing group. They're not officially members until the criteria are set and they become members. So that's why you call it an organizing group. You have a putative organizing group, and the BIA and the tribe can sit down and look at the history that shows what families had a connection into that tribe historically. And it can be because of their participation in the community, and they're identified. We identified them in those early affidavits. They weren't
Okay,
lying.
but I'm still trying to get to legal terms in terms of
Yeah.
what is the conclusion of an
So-
order supposed to say?
So the order would remand back, consistent with the Washburn decision, to organize the BIA to assist with organizing, which they were going to start to do based on the history of the tribe and the connection to Sheep Ranch. So there I go, where we had a family like Burley, not until 1998, any of the Miwoks connected to Sheep Ranch knew of her. And she got in, and then she took it. That's what they don't
But
want.
again, on the remand, are you saying that it goes back to the tribe to determine its membership?
Membership
and then-
criteria, yes,
Okay, and
exactly.
then the BIA looks at all of that,
Yeah, well,
or what?
Right. the BIA in organizing this tribe, has a role, because they had a role before. But they come in now, they've got the genealogy, and they put out a notice, like some have refused to submit a blood certification form. Why? Because they can't show that connection. So they have the people that want to be in the tribe come forward with their evidence that they had any kind of historical connection to the community. Then you come up with a group, an organizing group that sets the membership of the tribe, and then there's a vote on a constitution around an organizing group. We're not saying it's only the 1915 descendants. We're saying there's collateral relatives, or the relatives that have a connection in the Sheep Ranch. Hodge Dixie was collateral, but there's a number of them that work into that community.
Does the BIA have a proper role in approving the organizing group?
Yeah, I think if they go back, that's why I'm saying we're not trying to go back to 5 people.
Right. So I think that's right. And I think there is consensus between you and the government. And I agree with you both. The BIA has a role in approving the organizing group. And that just means I think the only question is, did the BIA carry out that role appropriately when it issued the Newland decision?
And my answer is no, because it didn't protect the political integrity of the tribe, which is what the remand decision said. Said the secretary must ensure she deals, or he, only with a tribal government that actually represents.
So our role and our only role, we read that Newland decision and we answer the question, did it protect the integrity of the tribe? And we do that under arbitrary and capricious review with a lot of deference to the Newland decision in terms of facts. Correct?
Right.
Okay.
That's where you go. And one thing is, we feel the court, this was before the Loper decision, gave Newland too much deference. He didn't follow the Section 80, Part 81 reorganization rules, where the membership criteria is set by the tribe.
What statutory text do you think the Newland decision interpreted incorrectly?
I have it right here. Let me grab it. It's okay. Assume the night was an historic tribe without applying 1981 regulations, and then it went. I have a definition of what a member is. I'm fumbling around, but basically under Part 81, the regulations state what a tribal member, the definition of a tribal member, and that is
I
a
haven't
member.
heard. Is that a regulation or?
Yeah, it's a regulation.
Well, I haven't heard.
Under a regulation under the IRA,
Right, but
under the IRA.
a provision of the IRA?
Yeah,
Or-
about how to, under the part about organizing a tribe. And they're saying a member for the purpose of organizing a tribe is someone that applies to the membership criteria, that satisfies the membership criteria and the tribe feels can be enrolled.
And there's a disagreement between you and the government about whether that definition means what you just said it means?
I don't know. I haven't seen that in their arguments here.
I guess what I'm saying is I don't think you and the government disagree about the meaning of the statute. And if that's the case, Loper is irrelevant. Loper goes to whether the government gets deference when it's interpreting a statute. I think where you and the government disagree is, while you agree about the meaning of the statute, you disagree about how it's being applied
Exactly.
to the facts of this
That's
case.
right.
Exactly. So Loper is irrelevant.
Well, a court, in her opinion, gave Newland's decision, she called it, she was going along with his urgency to do this as giving him deference.
Yeah, under arbitrary and capricious review in the APA.
Yeah. So
You're not the only one. It seems like every time we get a case that has nothing to do with statutory interpretation, but involves an agency, the challenger thinks Loper means they win. I just don't understand.
Interpretation is, about how to carry out the statute in terms of organizing the tribe. And so we would say that she gave him too much deference. Again, our position is that the group that was showing up trying to be in this process were totally overshadowed by the people that wanted to be a member and they knew did not have the historic connection. And that's why they wanted the process to show more integrity. So we stand on that side. And,
So are you arguing that the Newland decision was arbitrary and capricious because there was evidence before Assistant Secretary Newland that the Miwoks in the 1929 census were not necessarily members of the California Valley Miwoks?
right. In other words, there was good evidence in the record that, first of all, Sylvia Burley was a Jeff, but was clear she wasn't part of that. So not every Jeff that's on the 1929 census that they claim were related to Jeff Davis was part of that tribe, number one. And number two, they had a decision from the solicitor's office looking at whether to use in the Constitution, I think it was in 2013, the 1929 census. And the solicitor's office says, no, the census is too general. It's not specific enough. It's not legally sufficient as a membership criterion. It didn't identify who was who. It didn't even identify, it had some of the Sheep Ranch people on it, but it didn't identify people as tribe. Few were identified as with the Ptolemaic tribe, but it was just a general list. That general list was not accepted by anybody as these are the members of our tribe. And Calaveras is a huge county, 1,000 acres, a lot of Indian people.
Judge Childs, you have further questions?
Yeah, sorry, I'm getting too adamant, I know.
All right. Well, we've gone over time, but we'll give you a limited amount of time for rebuttal.
Thank you, ma'am, appreciate it.
And in the meantime, we'll hear from Ms. Sprague.
May it please the court, Mary Gabrielle Sprague for the Department of the Interior. Your Honors, the essential question, as you point out, is whether the Washburn and Newland decisions properly fulfilled the government's role to guide the electoral process. The court's decision, as you noted, is under arbitrary and capricious review, and we submit that the decisions were well-based in the law and in the facts of this case, and should be upheld as reasonable.
You just said you want to uphold the Washburn and Newland decisions. I don't think you mean that. Right?
The Washburn decision as revised by the Newland decision, correct. The basic principle of the Washburn decision, it was that there was a larger tribal community. He rejected the organizing effort, which had included about 200 people in the process, but found that there was insufficient outreach to the community, which had been repeatedly identified by members of the community as about 250 people. And Washburn was also responding, as did Newland, to the precedent of this court and other courts that held that the larger tribal community should be included in the organizational process.
But when you're talking about the larger tribal community being included, to me, that's a different kind of thought process about the greater community being involved in the tribal decisions as opposed to determining its membership.
Correct. I mean, Your Honor is correct that the process is that the Interior gathers in what is understood to be the larger tribal community, which is the term they typically use. And it's left to those people to decide in the Constitution what membership criteria they wish to propose. And they can propose a smaller group or a larger group. But at the outset, and this is clearly.
And you're talking about before, you're not talking about the choice in the Constitution, but you're talking about they can choose a larger or smaller group to be the framers of that Constitution. Or
Interior's duty is to gather in the larger tribal community, as this court recognized in its 2008 decision, although the court there was not addressing a secretarial election process, it was addressing a constitution that was offered to Interior for approval without a secretarial election process. But in either case, that the majoritarian principle to bring in the larger tribal community, among those people, they write a constitution which will have membership criteria, and then that group votes on the constitution. So the people, once they're gathered together, it's up to them to define the category of membership. And plaintiffs continually assert that the 1915 census descendants have a greater historical connection to this community than the other people. And that is simply not borne out by the record. Washburn recognized that the rancheria, when you have a small parcel of land like that, that not all the members of the community could reside on the parcel. And so he said that potential residents are potential members. And again, he was not deciding membership, but the potential members would guide the view of what the larger tribal community is. When you
talk about community, you mentioned the community, you mean the community of this potential membership community, the community that we are sort of a rough draft of who might actually be members of this.
That's correct, because of their known kinship ties with each other.
That was just a terminology clarification, because obviously there are people who live in the geographic community who may have zero.
That's correct. The Miwok community. And they identified themselves as Miwoks continually. When Indian Agent Terrell went to Calaveras County in 1915, he was sent to look for land in Sheep Ranch because it was a failing mining community. There was property to be sold. The government was looking for properties to buy. It was relatively close to employment. And so Terrell went there to see about buying land. And in his short time there, he identified 12 people who were either in Sheep Ranch, the town, or the Hodges were 2.5 miles north of Sheep Ranch. But he specifically said that this is a fluid group that includes other communities, 6 Mile, Avery, Angels Camp, that were to some extent interchangeable in their relations. I'd like to point out that this distinction that plaintiffs are making between lineal descendants and collateral descendants just depends on like what generation it is you focus on. If you go one generation older in time, these people are likely all lineal descendants because of these these marriage relationships and accompanying social relationships.
That relates to a question that I had, which is about the mistaken premise that John Jeff was descended from Jeff Davis. And in correcting that, why was it reasonable for Mr. Newland to conclude that all the 1929 descendants should be part of the eligible groups rather than just the descendants of John Jeff.
Right. And Your Honor, there were, when the BIA looked at the genealogies of people who had stepped forward around 2007, I believe, raising their hand that they wished to participate in the organization of the tribe, BIA identified about 17 people who were 1929 census descendants other than the John Jeff descendants. So it's a small group of people.
But wouldn't including the 1929 census include Miwok's descendants who are now potentially members of other Miwok tribes?
Your Honor, there are no other Miwok tribes in Calaveras County. There are rancherias and recognized tribes some further miles away in the surrounding counties. On the 1929 census, it did identify some Indians as Tuolumne, and they were not included as part of the organizing group. And also, BIA decided that people listed as Miwok Tuolumne would not necessarily be included as part of the eligible group to organize, although it could be left to the members once the organizing group and drafting the Constitution, they could potentially have decided to include mixed Miwok Tuolumne. But anyway, it was.
And was it necessary to include the John Jeff descendants in this first instance, or is that something that could be decided later on after a tribe is organized?
No, because by excluding the John Jeff descendants, you ended up with 10 people. And that clearly is by no account the larger tribal community. Whenever this tribe has been asked to participate in 2007, as I said, when BIA announced we're going to hold an organizing meeting, please indicate if you're interested, they got about 250 responses. When the tribe organized in 2013, and it was not through a secretarial election, they gathered together a list of 200 participants. In 2018, as it turns out, when the tribe organized after the Washburn decision, I think there were 279 people on their list that they recognized as this broader tribal community. In the 2011 affidavits that were submitted in connection with the CVMT3 litigation, people described the activities, the tribal activities that they engaged in together. So that the evidence throughout, whenever the Miwoks in Calaveras County were asked to raise their hands and say, do you consider yourself a part of this community? They have 250 people or so raising their hands. And that guided the decision. And that is why your specific question about the few people who were 1929 census descendants, but not John Jeff descendants, Washburn could have gone either way. And Interior has significant discretion in its management of Indian affairs. Washburn said, well, I'm going to leave it to the tribe to decide about those people, but he said it could be proper. It wasn't precluded. It could be proper. And Newland was guided by the fact when he looked, as I said, at the 2013 organizing effort and the 2018 organizing effort. In both cases, the tribal community, including plaintiffs in this case, accepted this group of 250 or so people to come together to draft the Constitution.
But when people are raising their hands to be included, is the BIA at that time checking to see if they are indeed members of the California?
Yes, they absolutely were. So you raise your hand and you submit a genealogy that shows how you're connected to Miwok ancestors, and that is reviewed. It was considered, I mean, the 1929 census was preceded by the 1920 census, the 1910 census. These were comprehensive censuses of Indians in Calaveras County. And these names continually appear. They were known to the government. After Jeff Davis passed away in 1940 and the land on the Rancheria was available, members of the community would contact BIA and say, we'd like to live there. And consistently through the 40s, 50s, 60s, when the land was disposed of to a 1929 census descendant, the BIA recognized 1929 census descendants as eligible to live on the Rancheria, giving no preference to 1915 census descendants. So the notion that somehow to have an ancestor, a lineal ancestor on the 1915 census gives you a special right or a special knowledge, as plaintiffs seem to be claiming now, either as a right to be the members or as special knowledge to give them a special status in organizing, simply isn't supported by the record. And and Newland well documented his reasons for revising the Washburn decision as he did. I think Your Honors covered a lot of the material I would have covered in your questioning. And if you have further questions.
Make sure I follow. The government is not asserting a right to decide the ultimate membership of this tribe.
That's correct.
The government is asserting a right to approve the organizing group or larger tribal community that will write a constitution and itself decide membership of the tribe, correct?
Correct.
And years ago, these plaintiffs or these petitioners agreed that the government plays that role, correct?
Correct.
And in fact, they brought legal challenges to the government's to make sure that the government played that role correctly.
That's correct.
Okay. Then so that's very big picture. And then I have a very in the weeds question. There's a line in your brief. It says, the U.S. currently holds the land in trust. I assume that means the Rancheria.
Yes.
For the benefit of the descendants of Mabel Dixie's heirs who are not 1915 census descendants.
Right.
And then Ms. Walker said that Mabel Dixie's heirs have no descendants.
That's incorrect. There is one descendant of Merle Butler, who was her common law husband, Dakita Boire, and she would be included under the third eligible group.
Okay. Under the Newland decision.
Under both.
Under both.
Right. Yes, it's, as you pointed out, Your Honor, and it took me a long time to figure this out. It's Mabel Hodge Dixie, her heirs, and their descendants.
But her heirs' descendants are not 1915 census descendants.
Right.
Okay.
Yes. If that's all the questions, thank you very much, Your Honors.
Thank you.
I respect Ms. Bragg, but I have to disagree with how she's categorized the Miwoks in Calaveras County as all having the right to be a member of Sheep Ranch. That is just not correct. Tribes, you can have a lot of Sioux people in North Dakota. They're not all member of the same tribe. They have a lot of the same names. I represented Henry Jeff of the Choi Numbi, and he's on the coast of California. There's a lot of Jeffs, a lot of Miwoks in California, but they don't all belong at Sheep Ranch, and not all the Miwoks in Calaveras County have that connection. For example, this is why it's you know, you have to be a genealogist to get into this, and I've done a lot of it. But basically, what happened with Sheep Ranch is as Michael Melimbez identified in his affidavit, and this is what we stand on. He was fighting to overcome a woman that was trying, a rogue leader, run off with their heritage. And they said they pulled together and they had a list of people that they were all part of this community over a number of years, had lived there, like Velma White Bear, Miss Carson. And they were related to one of the Jeff families. It was the Hattie Jeffs, because Maple's mother was Hattie Jeff, and that was the daughter of Tilly and John Jeff. But Hattie Jeff's relatives had a connection, some of them, into Sheep Ranch, and her oldest sister, Laurel, they were close, her line had a connection into Sheep Ranch. But the other 7 children of John Jeff did not. So not every John Jeff descendant has a right to be at Sheep Ranch. And what happens is, in America, tribes find out the reason why they don't just blanket bring in anybody that has Sioux blood or anybody has Miwok blood into their community is because people marry out. They marry out and they go into other communities, whether they go into a white culture, a black culture, another culture. They don't come back. They're not part of the political community. And that's what we're talking about when you say political integrity. So no, I disagree strongly that every Miwok on that 1929 census would have had a descendancy or a historical connection. So that's why I don't want you to get held up.
I understand that in your view, the 1929 census descendants would be over-inclusive.
Yes.
If we did not allow the 1929 census descendants to be part of the organizing group, would that mean the organizing group is under-inclusive?
No. What Kevin Washburn said, and this is on JA 266.
I mean, if the answer is it's you say it's not under-inclusive.
It's not going to be under-inclusive.
That means that
Because it's not going to be limited to 9 people or 5 people. Washburn said, whether the descendants of the Miwoks identified in the 1929 census shall be included in the organization of the CVMT is an internal tribal decision and shall be made by the individuals who make up the eligible groups. And he drops down the footnote and he talks about the controversy over Burley. And he says, well, if she can prove that she's got that connection, then they can decide to bring her in and use the 20, as she shows up on the 29 census. But the point is, not every Miwok came into there. They may have married out. They may have gone to other tribes in other parts of California. So that's why to just list those on that 29 census without any trace. And I, again, disagree.
But that very paragraph seems to recognize the reasonableness of the not yet made Newland determination broadening Washburn's baseline decision. He said in the previous sentence, including the descendants of the Miwok Indians identified on the 29 census as eligible to take part in the organization of the tribe may be proper in light of Agent Terrell's conclusion that to some extent the Indians of Sheep Ranch, Murphys, 6 Mile, Avery, and Angels are interchangeable in their relations. So he made a decision, as you point out, that would leave to the narrower group the ultimate membership criteria reflected in the Constitution. And if they wanted to encompass more of those people, Newland took a different default and said, let's have more people in the organizing group, and they could go the other way. They could recognize, well, I belong to a different tribe, or they have to do some kind of genealogical discussion and connection to the region, the area, recognition of different, maybe independent Miwok tribes. But it seems like Washburn himself recognizes that a reasonable alternative route for BIA would be to do precisely what Newland then does.
But the reason he came down with the 3 eligible groups was because the government's role was to identify that history. And then the tribe's role is to identify its members. So he was saying that he's identifying history. Does the tribe exist? Like the remand decision demanded, you have to determine a tribe exists. He looked at historical roles to say, yes, Sheep Ranch was identified and there are descendants today, the tribe exists. Then he's distinguishing, this is the point I'm trying to make, and I don't know if I can possibly be clear enough, but there's a big distinction in saying with Washburn, look, sure, we have a general Calaveras County census of 1929 that identifies people that have interchangeable history, just like the Sioux, just like the Virginia tribes, they have interchangeable ancestors. But they have to then decide if those ancestors, which one come in. And like Michael Melendez did and the others in their affidavit, there were some that had the Jeff descendancy and their ancestor, John Jeff, was on the 29 roll, but he was showing the history and they were showing the history of their connection to Sheep Ranch, whether they had lived there, been part of a cultural things with them, but there is that history.
Can I run down
I
one
know.
factual dispute that I know the government have had? They have this line in their brief: U.S. currently holds the land in trust for the benefit of the descendants of Mabel Dixie's heirs who are not 1915 census descendants. You heard Ms. Sprague's explanation for why she thinks that's accurate. Do you also think it's accurate?
The land wasn't held in trust like a reservation, we know, in trust for this tribe. It was designated, they were doing land purchases for the homeless Indians in California. And that 2 acres they identified for the community around that Sheep Ranch area, because I think they knew that Sheep Ranch mining town.
Is the U.S. currently doing whatever that is for the descendants of Mabel Dixie's heirs?
Well, that 0.9 acres just isn't like a residential community. It never really was. It was, Yakima was on there, Maple was on there, different people were on there, but that is not like being a resident of, a big reservation like Crow Agency or something.
So whatever.
So I'm not sure I'm understanding the
whatever the
distinction.
U.S. is doing with that land, it's doing it for the benefit of some group of people.
It was the Miwoks around the Sheep Ranch
And
area.
is it currently doing it for the benefit of Mabel Dixie's heirs her
No, because she has that deed. What they did is they transferred to Maple the deed to the property, and then her heirs, and she left it to Yakima, who left it to Velma White Bear, who lived at Sheep Ranch, who their grandmothers were sisters. And so she was a cousin, and she was in the Rancheria, the Sheep Ranch Rancheria community. That's an example.
Mabel Dixie's heirs have the deed, you just said, right?
No.
Some kind of deed.
Maple, the deed to Sheep Ranch is with Velma White Bear, who is a cousin of Yakima because Velma's grandmother and Maple's mother were sisters. And so what Yakima did is he got the land and it was deeded to him. And then he passed his rights on to Velma, his cousin, who was a Sheep Ranch Miwok because she was in the community. So that's why the fact the government is saying you can take all the Miwoks that descend from the 29 census that had no connection or their later generations connection back into that thing and then let them have the tribe. That violates the political integrity of the tribe and that violates the remand.
Okay, did Ms. Sprague say anything at oral argument about that sentence that was inaccurate?
I don't remember if she, I just, that's what I know. And I have, I know that Velma's heirs have it.
Anything further, Judge Childs?
Yeah, because of the, going backwards, because of the IRA and the allotment era of the land that we were just talking about on the Sheep Ranch Rancheria, is that held in trust the same way a reservation is?
No, it never was put in trust like a regular reservation.
Okay, and then earlier when we're talking about the broader Miwok community reflected in, for example, Calaveras County, is there a difference on utilizing a broader community for purposes of your organization than it is for when you're actually determining citizenship for yourself, for your self-determination and self-governance purposes?
Yes, And that's a good question because what we claim Newland did, where he overreached, was he designated this 1929 census to designate membership. And that's where, again, Washburn had it in his attachments, attachment L, by Director Rissling, had a solicitor's opinion that said you cannot use the 29 census as a membership criteria. It's too general. And so and Washburn could have, but he didn't, because he said that is for the tribe to determine whether somebody on that census has the right to membership in the tribe, not me to say that everybody in the 1929 census should be in membership. Now, when you come to the putative group or the organizing group, what our position is, when you look at the affidavits of Melendez and the group that he was with, they were identifying people that have had that history. So when the BIA sits down, if you all go back to the say Newland went too far, overreached, that's arbitrary and capricious decision making, then what the BIA was starting to do was sit down with this group and look at people that requested to be part of the tribe and see if there's documentation that shows a historical connection, not only in name, but how they connected to that Miwok community in that area. That's, it's just like, I use Virginia because I know those tribes so well. The Pamunkey do not have land in trust. They have an old state reservation. A few miles away is the Mattaponi. They have an old state reservation. Neither one of those pieces of property are in trust. And those properties aren't big enough to hold everybody that has Pamunkey heritage or Mattaponi heritage. So they have membership with people both on that live there on that old state reservation, people off. And that is so common. But they trace it back to who has a connection to that tribe. So it's not like everyone and they have interrelations. They have people with the same last name in those two tribes. So it's not about that. That's why I think the government overreached. And I know I'm beating the same drum. But.
And then the last question I had was just, there was a discussion in the district court's order about plaintiffs have been here several times challenging things that they're now taking a different position on. So I just wanted you to speak to that.
No, I think it's very consistent. What they were fighting for in the beginning is they had a rogue leader come in and took the tribe and took the money. And they were fighting that. And they were on the side of we want, a legitimacy. And they won. And then they had to challenge again because she challenged again, and then they won. They got the remand, which said that, the government had to go back and show, number one, a historic community existed, and then they had to honor with their trust responsibility, the political integrity of the tribe. And that's the part I'm fighting over. It's nothing's harder than figuring out tribal membership. So I appreciate you all indulging with this conversation, but it's a very big difference in Indian country between being over-inclusive and setting up the situation where the right people, and I mean people with historic connection, come into the tribe. And the BIA can be a mediator in all that because they can have the documents. What they failed at was they didn't do their due diligence. And now they're trying to use that lack of due diligence against these folks I represent that definitely have been fighting to have a broader community. That's what they fought for. If you look at those early cases, exactly. They said, we don't want our tribe being hijacked by Sylvia and her two children.
Right.
Yeah, you've heard me enough, but thank you very much. I appreciate it.
Thank you. And the case is submitted.
All right.
Case number 24-7185 et al. United Mexican States versus Lion Mexico Consolidated LP, Hector Cardenas defendants. Mr. Becker for appellant United Mexican States, Mr. Parada for appellant Hector Cardenas, Mr. Conlon for the appellate.
Morning, Mr. Becker.
Good morning. May it please the court, I am Stephen Becker from Pillsbury, Winthrop, Shaw, Pittman, representing petitioner, the United Mexican States. We believe there's two key issues raised here. First, when the relevant language of an arbitration agreement is clear and unambiguous, can arbitrators disregard that language by purporting to do an interpretation? And second, does a reviewing court have the discretion to repair a defective award by recharacterizing its language and setting out new reasoning on behalf of the arbitrators? Obviously, we think the answer to those questions is no. With regard to the first point, we think allowing arbitrators to avoid clear language would be inconsistent with the Supreme Court statement in MISCO that the arbitrator may not ignore the plain language of a contract. Other courts have agreed that if the language is clear, arbitrators cannot make interpretations. For example, in XL, the Eighth Circuit stated, when the language of the contract is clear and unambiguous, the arbitrator may not rely on parole evidence. The Eighth Circuit also stated in Missouri River that an arbitrator cannot rewrite the contract and add new terms, which is what happened here in this case. The Seventh Circuit has similarly ruled in U.S. Soccer Federation and Anheuser-Busch that an arbitrator cannot declare an ambiguity when none exists. Article 11501 is clear and unambiguous, and the tribunal itself acknowledged its literal reading. The obligation in 11051 refers to treatment of investors. Refers to treatment of investments. Other obligations in the same chapter, indeed in the same section, refer separately to treatment of investors and investments. But the tribunals, go ahead.
Can you think of an example of an instance where a country violates 11051 and that violation is challenged in arbitration?
Sure, there have been dozens of cases that have challenged violations of Article 1101.
And appropriately challenged the violation.
Yes, I've been arguing.
What's an example of one?
Lowen versus United States case, arguing that the U.S. courts denied justice to the subsidiary, U.S. subsidiary of a Canadian company. There's an example.
Who brought that arbitration?
The arbitrations have to be initiated by the investor, and they could bring claims either under Article 1116 on behalf of themselves and or under Article 1117 on behalf of an enterprise that they own or control in the other country.
So that's what I would have guessed, is that an investor brought that arbitration in order to vindicate the protection of investments in 11051.
Exactly, to vindicate the investment, its investment being a U.S. company.
Yeah, so I thought that's what the other side was saying is allowed and happened here. And I thought your argument was that an investor cannot vindicate 11051 because 11051 protects investments, not investors.
The issue, and the district court conflated the issue of how to initiate an arbitration, the rules for that, and the legal standard that applies. The issue with Lion was that it was arguing about the treatment of itself as an investor in the Mexican courts, not the treatment of an investment. And the NAFTA parties have been very clear that 11051 only applies to the treatment of investors.
The arbitrators and the district court found that it was actually the treatment of the investments that was being reviewed.
No, Your Honor, all the arguments in the arbitration award related to the treatment of Lion Mexico in the U.S. courts. In the Mexican courts.
But it was the treatment of their investments in
No, it's the treatment of them. They complained that the Mexican courts didn't treat them appropriately by not giving them sufficient opportunities or ruling in their favor on various issues.
Maybe the opposing counsel can address this, but my understanding is they were complaining that we were mistreated as investors, but in light of mistreated in our protection of the investments.
But, Your Honor, that's not what the arbitration agreement provides for. There are other provisions in Chapter 11 that expressly state that the obligations are owed to investors. So, for example, in Article 11052.
I read
Yeah, okay, yeah, you've seen
I
that.
read it, and I mean, the district court was all over this in the decision, in her decision, but also in the argument, the oral argument, the hearing. I mean, I think if it seems like you're backing away from, or maybe you never made the argument that 11051 must be read so literally that only an investment can initiate arbitration to protect it. No, you're saying, of course, an investor can initiate the arbitration to protect an investment. And so then really just the arbitration panel is really just trying to figure out, okay, was this a Mexican court's mistreatment of an investment or mistreatment of an investor? And that just seems like heartland decision for an arbitration panel to decide, not for a court to come in and say, oh, no, you weren't even interpreting the arbitration agreement.
Your Honor, the problem is that in effect, the arbitrators added new words to Article 11051. They added investors, or they modified the express definition of investments to include investors. And there are specific definitions of investment and investors, which you disregarded.
It's very strong evidence that the tribunal did consider investments insofar as it dismissed Lyon's claims relating to promissory notes on the ground that the promissory notes are not investments under NAFTA. Why isn't that very strong evidence that the tribunal properly focused on the nature of the investments and not only on the owner?
The issue in the preliminary hearing or preliminary phase on jurisdiction related to, excuse me, I have to say, I'm trying to reserve 1 minute for rebuttal and I see I'm out of time. I hope I can continue.
You may.
Okay, thank you. The issue in the preliminary jurisdictional phase was whether Lyon Mexico had an investment within the meaning of the NAFTA to begin with. And so Mexico argued that the mortgages and the notes were intertwined. The notes were for a term of less than 3 years, which under the definition of investment doesn't qualify as a covered investment. The tribunal decided to separate the mortgages from the notes. And they said, okay, the notes aren't an investment, but we'll hold that the mortgages qualify on the basis that they are intangible real estate.
Well, so they're looking at the nature of the investment
Right.
and applying Article 11051 to protect the investments.
No, excuse me, Your Honor. Lyon Mexico brought multiple claims. It argued that there had been an expropriation. It argued other issues. So 11051 was one of several alternative claims. If we were talking about, if the tribunal had made a ruling on expropriation, this issue about the difference between investments and investors would be irrelevant.
Right.
Right. But the tribunal decided not to address that claim.
I'm not sure how that supports your argument, though.
I'm saying the people are suggesting, the lower court was suggesting, I have to fix 11051 to give these people an opportunity to bring a claim. The response is there are several alternative bases upon which people can bring claims, including denial of national treatment, expropriation, et cetera. Right? So the rule about what's an investment applies in all of those contexts. That gets to whether you have standing to bring a claim, any claim to begin with. It is not inextricably tied just to the issue of 11051.
Judge Childs, do you have any questions?
Well, just that when you're pushing us to a literal reading and suggesting that somehow the arbitrator goes beyond their power, but what about how much deference you give to the arbitrators interpretation generally?
Your Honor, there's a distinction in the cases between situations in which language is ambiguous, and then there's great deference to the arbitrators in interpreting ambiguous language, and other cases in which the language is clear and unambiguous, which is our position here. There was no reasonable manner in which the 11051 can be read to discuss treatment of investors. It's simply precluded by the definitions, by the clear language. Even the Federal Trade Commission interpretive statement that was cited specifically says 11051 prescribes the customary international law minimum standard of treatment of aliens as the minimum standard of treatment to be afforded to investments.
But I don't take Lion to be arguing that we should read it to apply to investors. I think they're saying that the tribunal appropriately treated it as applying to investments. And so what in the tribunal's decision most clearly supports your position that they actually lost sight of the focus on protecting investments? I mean, obviously, if you protect an investment, you help the owner of that investment. And that's just unavoidable.
Yes, but the point of NAFTA Chapter 11, it has very narrowly prescribed circumstances in which a claim for damages can be brought. And that's what we're talking about here. There's no general right to sue foreign governments for money under international law. The terms are prescribed here, just as they might be in the Federal Tort Claims Act, right? It can't just be not all government misconduct is entitled to financial compensation. The key point in response to your question, however, is the tribunal expressly said, the tribunal finds that NAFTA Article 1105 doesn't grant protection to Lion as an investor. That's on page JA 110. They were very clear. I think people now, sorry, excuse me.
No, I was just going to say, you seem to believe that the interpretation is wrong, but not that the arbitrator did not interpret the treaty.
we think the arbitrators made a fake interpretation. I think the expression is noises of contract interpretation, because they cited items like the Free Trade Commission interpretation that don't support their conclusion. But our main point is that when the language is clear, is not reasonably capable of being read in another manner, the arbitrator should not have engaged in an interpretation.
Okay. Any other questions from my fellow panelists? All right, we'll hear now from Mr. Parada.
Good morning, Your Honors. May it please the court, my name is Luis Parada for moving appellant Hector Cardenas. Mr. Cardenas is an integral part of this dispute, so much that because of what the arbitral award said about him, if Mexico is forced to pay the $77 million, Mr. Cardenas himself is going to have to reimburse that money to Mexico. This is why he moved to intervene under Article 20, under Rule 24 of the Federal Rules of Civil Procedure to support Mexico's petition to vacate the award with two additional arguments. One of these arguments deals about jurisdiction, the other one about due process to him. The district court denied Mr. Cardenas' motion to intervene on three different grounds. I'm going to address only one, futility, because of the impact it has beyond this case. District court ruled that even if Mr. Cardenas complied with all the requirements and their Proof 24, he would not be allowed to intervene because intervention would be futile because the courts of the U.S. cannot review issues of jurisdiction. Well, it is true that most, if not all arbitration rules reserve for or indicate that the arbitrators have the power to decide on jurisdiction. That does not mean that arbitrators have the sole power. that they have the last word on jurisdiction. Because as a general matter, an arbitral award is subject to further review. In arbitrations under the Exit Convention, like this court has seen many, the Exit Convention itself has its own mechanism to review awards by tribunals, including decisions on jurisdiction, and to annul those awards when they, for example, exceed their powers.
But Mexico actually defended against the arbitration award. And so I understand you to mean that your argument is that your interest is distinct based on this jurisdictional claim. But that sounds like maybe that's more of a litigation strategy?
No, Your Honor. Mexico could not have possibly made this this argument on vacator because they failed to make it during the arbitration. On the other
Would you
hand,
be seeking vacator of the entire award or a partial modification?
vacator of the entire award. So,
And your
And how does
client
that
did
not
not,
prejudice everybody already in this litigation for what, a decade?
could you please repeat the
How
beginning?
does that not prejudice everybody who's already been in this litigation?
Well, the one that is really prejudiced here is Mr. Cardenas, because he's the one who's going to have to end up paying the 77 million award if it is enforced, and he was not even allowed to be. The arbitral tribunal made very serious findings against him, blaming him basically for committing fraud and orchestrating a fraudulent scheme, forging documents without him being present. And he, because of that, for example, the state of Nayarit, where one of the properties that was in the joint, supposedly joint investment is located, has already started expropriation proceedings against this property, which is valued at more than $800 million. So the prejudice is to Mr. Cardenas. Mr. Cardenas is only asking for due process.
but Mr. Cardenas was aware of the arbitration, and the district court held that he didn't seek timely to participate there. You fault Mexico as a representative of the same interest by saying they failed to raise any objection, the jurisdictional objection in the arbitration. Well, so did Mr. Cardenas fail to raise any jurisdictional objection or any objection whatsoever in the arbitration. And that was a decision that he made, thinking, oh, this is, I can rely on the existing parties. But that's a choice that he made, that he has to live with.
Respectfully, that is not correct, Your Honor. In international arbitration, it's not like here that people can be hearing us live and can read the transcript, can be hearing a recording, they can be present here in the courtroom. This arbitration was under closed doors. It was
All
not
the more
public.
reason that Mr. Cardenas might have thought, I need to be there because I cannot otherwise monitor.
There's no right.
There's no right, but you know that you can petition to address a tribunal,
He had his lawyer, Mr. Ivan Mercado, petition 5 times
not for himself.
for his companies, because Mr. Mercado is a lawyer and Mr. Cardenas is not. So the one that would have to be before the tribunal would be Mr. Mercado for raising the issue of jurisdiction, which related to his cases that he had
But he petitioned for a different party, not for Mr. Cardenas.
for Mr. Cardenas' companies. I mean, the thing is, the problem here is not that he was not present. The problem is that he was not present, and the tribunal made very serious findings against him in his absence, and that is violation of due process.
But his lawyer knows that arbitration and the business community has fought for and prevailed in this, that there needs to be finality. So there's very, very limited review as we face today here. If they arguably interpreted the contract, then that's enough. And so anyone who has interest that may be seriously implicated in an arbitration would do well at least to preserve the effort to intervene in the arbitration, no? To petition to be there, because as you say, once it's done, the reasoning is not subject to much review at all.
It is, ma'am.
The
It is, Your Honor.
process, pardon?
The ruling is subject to review under Section 10 of the
It's
Federal
subject to
Arbitration
review. I said
Act,
it's a very limited review, as we all know.
excess of powers.
It's very limited, yeah.
In exit arbitrations, you can this arbitration, if it were held now, it would be under the ICSID Convention because now Mexico is party to the ICSID Convention. This decision, this award would be reviewable by an annulment committee, by an ad hoc committee for excess of powers. And they would decide if the tribunal exceeded its powers and they could annul this. The same is true for an arbitration under the extradition facility rules, especially because the courts of the federal courts of Washington, D.C. are the courts of the seat of the arbitration. Only the district court can vacate an award, and this is what we have.
Did Mr. Becker say anything today that you disagree with?
No, he did not.
Is there anything in his brief that you disagree with?
No, I think Mexico's argument is correct.
It sounds like your interests were pretty well represented.
No, it was not, because we have the additional two issues, due process and jurisdiction, are personal to Mr. Cárdenas, and they are arguments that Mexico cannot make. Because actually Mexico was participant in the violation of due process against Mr. Cárdenas by, one, not calling him as a witness, not even wanting to meet with him. And actually, I'm sure you have read the briefs, Mexico threw Mr. Cárdenas under the bus. And that's why Mr. Cárdenas has to now, before the court that is deciding petition to vacate the award, under Federal Arbitration Act, Section 10, Mr. Cárdenas appearing to you to finally get the opportunity to have a due process. Otherwise, the governor of Nayarit is already there for a year and a half with an expropriation process to expropriate an $800 million property, supposedly because of what Mr. Cárdenas did as alleged in the award. Mexico has not moved a finger to stop the government of Nayarit. Mr. Cárdenas is fighting for his own right to due process, which is not being deprived of life, liberty, or property with a due process of law. And this is what he has been suffering. He just wants to have his day in court. He hasn't had it yet. And not because of his fault. Again, the problem is not that he was not present. The problem was that not being present, the tribunal made very definite and damning findings of fact against him that are being used against him to deprive him of substantial property.
All right. Thank you. And we next hear from Mr. Conlon.
May it please the court. I think I'd first like to address one of the arguments that Mr. Becker made about investment of investor and whether what the tribunal did here was consistent with Article 11051. The proceedings that were commenced here was because Lion Mexico's mortgages were canceled, and Lion Mexico was not given the opportunity to challenge the cancellation of those mortgages. So this started with an investment. Before the tribunal, Mexico argued that an investor of a party may not bring a claim on behalf of an investment unless the investment is an enterprise of another party that is a juridical person that the investor owns or controls directly or indirectly. Now, investment is defined in Article 11 under 1139. There's 8 different categories of investments. The investment at issue here is a mortgage, and that was the tribunal held that it was an intangible interest in real property. Pursuant to Mexico's argument, 7 of the 8 categories of investments cannot be protected by an investor under 11051 in a NAFTA proceeding. So that was the question presented to the tribunal. How does the tribunal give effect to the purpose of 11051, which is to protect investments, if 7 of the 8 listed investments are not subject to protection, as Mexico argues? As the court noted, judicial review of international arbitration awards is extremely limited. Courts don't sit to hear claims of factual or legal error by an arbitrator as they would in reviewing decisions of lower courts. Even if the tribunal was incorrect in its analysis, that is not sufficient. if the tribunal even arguably interprets the contract, or in this case, a treaty, it must be confirmed. The tribunal found that the conduct of Mexican courts in canceling Lion Mexico's mortgages without notice and refusing to grant Lion Mexico an opportunity to present evidence to demonstrate that the mortgages were canceled as a result of fraud violated both Mexican procedural rules and elemental principles of due process under international law.
Let me ask you, Mr. Conlon, in the arbitration proceeding, and I know there's not transcript of that, but did Lion ever advance the argument that Article 1105, what is it, 11051, protects it as a foreign investor from unfair treatment,
So
even when that unfair treatment is not tied in any way to a particular investment?
Lion Mexico argued that under the circumstances of this case, in order for its investment to be protected, Lion Mexico needed to act on behalf of that investment. It was not a juridical entity. It could not do anything on its own to protect its rights in the Mexican legal system.
So it addressed this juridical entity argument, but it was making assertions there to protect the mortgage investment.
Correct. Because there's only one, under the definition of investment, which is an enterprise, that's the only type of investment that is a juridical entity. The others include like equity securities, debt securities, a loan. None of those other defined investments are juridical entities able to act on their own behalf. There's no dispute here about the factual findings of the tribunal. There's no dispute that the mortgages at issue here are protected investments under NAFTA 11051.
What about the timeliness? Why isn't the timeliness taken care of by, because Cardenas is not really asserting a separate cause of action. It wants to participate because it sees Mexico not advancing some of the arguments it would want to make. And Mexico has timely raised the substantive claims. So why is there a timeliness problem?
With respect to intervention?
Mm-hmm.
Well, for several reasons. One, the Federal Arbitration Act gives a hard 3-month deadline. He missed that by 8 months. Secondly, he's looking to interject entirely new issues that were considered and rejected by Mexico in terms of raising them before the tribunal. Well, the jurisdictional argument was raised before the tribunal by Mr. Mercado. Neither the tribunal nor Mexico wished to pursue that. Mr. Mercado was not allowed to proceed because he did not provide necessary detailed information about his personal background and his standing to participate as a non-participating party. But
in terms of the timeliness, if the jurisdictional issue was raised, there's not any kind of sandbagging or belatedness. If Mexico's in, the issue's been put on the table in a timely manner, then why doesn't Cardenas's participation kind of date back and say they're as you said, they're kind of leaving the jurisdictional issue aside they didn't want to pursue, but he does. So just in terms of timeliness of intervention, everyone knew what they were up against.
Right, but it would have the perverse consequence of issues being considered by a state party here in Mexico, them choosing not to raise that issue, yet some intervener could raise an issue that's only for Mexico to raise and justify bringing that up for the first time in a reviewing court, such as the district court, when it chose as a tactical matter not to raise it before the tribunal. Likewise, the due process concern, there's no due process here.
Doesn't that go, when you say it's only for the state to recognize, doesn't that go to the merits of his claim that, he's not bound by this arbitration judgment and...
Cardenas?
Yeah.
Yeah, he's not bound by this arbitration judgment. There's been no submission. There's a statement that he's required to indemnify Mexico for this judgment. There's nothing in the record to that effect.
Right. And in terms of, due process, which he raises, he can't be bound by a process that he wasn't a participant in.
Correct. And he makes no argument that there's any res judicata effect, there's any collateral estoppel effect from this judgment. This award may well have been cited in different proceedings in Mexico, but that does not give him the right to now upend the appeal. He in his motion to intervene, he says that he's not looking to challenge the factual record that was asserted by the court. So what is the purpose of, what rights are being validated in the proposed motion where he's denied due process if he's not challenging the factual record?
And because this is similar to what Judge Pillard was saying, what you were saying, but because he was not party to the arbitration, he has at least left open the possibility that when Mexico or someone comes after him for money and attempts to use the arbitration decision against him, he's left open the possibility that it shouldn't apply against him because he wasn't a party to it.
Correct.
So his decision to not join the arbitration may have been a very self-serving strategic decision.
Right, a tactical decision to try and get two bites at the apple.
Right.
Or to be able to plausibly deny. So he says, what do you mean I don't have a legally protected interest that's threatened? Here, I have to pay $77 million. And your response to that?
Well,
Nothing in the record on it.
there's nothing that indicates he has to pay $77 million. If the tribunal's award bound him to pay $77 million to reimburse Mexico, that would be a different issue, but that's not the factual situation that we're presented with here. There's no case that Mr. Cardenas has cited or that we've seen in which someone in the position of Mr. Cardenas has the ability to intervene. He does not have the legal interest. The cases that are cited involve non-parties who are bound by the award. In one case, a non-party had to pay $1 million pursuant to the award. There was a case involving a union where the international portion of the union was bound by a decision involving one of its local unions, local chapters. That is not at all the circumstances that are presented here.
Anything more, Judge Childs?
No.
All right. Thank you.
Thank you.
And did anybody reserve any time?
I do.
A minute each. Okay. Mr. Becker?
Yes, Your Honor. This issue that Counsel for Lyon raised about, 7 or 8 categories aren't protected or what have you. First of all, again, the scope of what parties can seek under Chapter 11, in a claim is very well and narrowly defined. Parties had their intention and it's clear. Second of all, that's not an issue that was discussed in the award. And people, it's similar to the district court, they're trying to add a gloss to the award itself to say, well, this is what the arbitrators must have been thinking, or here's another justification for their ruling. And we would submit to you that's not proper, that the award has to stand on its own 4 corners. And if the arbitrators, can't supplement the arbitrator's reasoning by saying, well, we wish the NAFTA was broader, or we want to second guess what the U.S. and Mexico and Canada negotiated. That was the only point we wanted to make.
All right. Thank you. And a minute by Mr. Parada.
Your Honors, I would bring your attention to tab 19 of the joint appendix. And there you will see that the expropriation decree that specifically targets Mr. Cardenas and his properties because of the responsibility assigned to him in the award as the perpetrator of fraud. But let me just tell you something else. This case for Mr. Cardenas is not only about the money. That is half of the problem. The problem is the lack of due process given to him has ruined his reputation. He's already been in jail 3 times because of the allegations that the Lion made in criminal proceedings against him using the same measures in the award. So for him,
It can't be right that it's just the arbitration award. I've never heard of a criminal prosecutor relying on a private arbitration.
I did not.
And it's factual findings
That is-
establishing criminal activity.
That-
And I assume that Mr. Cardenas had due process in any criminal proceeding for which he was.
Your Honor, I may have misspoken. It was not, the criminal proceedings were not predicated on the award. But I was just talking about that was for the money part. But that has also, the award has damaged his reputation. Aside from that, Mr. Cardenas because of criminal accusations by Lyon, has been imprisoned in jail 3 times. It was even before the war.
And he presumably, I mean.
He's been exonerated in all the Mexican court proceedings where Mr. Cardenas has been present. He has been found not guilty, exonerated completely, but it and the award have caused a lot of damage to his reputation, in addition to what you will see in tab 19.
All right. Thank you.
Thank you. Thank you, Your
Case
Honors.
submitted.
Up to you. I'm good either way.
Number 25-5243.
I'm sorry. I'm sorry to interrupt. So like, can we just take a 5-minute break?
Absolutely.
Stretch our legs and come back?
Stand. This honorable will now be brief recess. Stand, please. This honorable court is again in session. Be seated, please. Case number 25-5243. Refugee and Immigrant Center for Education and Legal Services et al. Versus Kristi Noem, Secretary of the U.S. Department of Homeland Security in her official capacity et al. Appellants. Mr. Ensign for the appellants, Mr. Gellert for the appellate.
Good morning, Mr. Ensign.
Good morning. May it please the court, Drew Ensign, Deputy Assistant Attorney General for the United States. I'd like to reserve 4 minutes for rebuttal. The January 20th proclamation is a permissible exercise of the president's extensive powers under Section 1182F and 1185A. Through the proclamation, the president has imposed an entry bar at the southern border. Plaintiffs do not genuinely dispute the legality of the entry bar itself, but instead argue that they can nonetheless violate it with impunity. Essentially, that as long as they manage to enter the United States, notwithstanding the entry bar, they cannot be quickly repatriated and instead gain access to the asylum system as a direct result of their unlawful entry. Plaintiffs are mistaken. This court's stay panel correctly concluded that the government is likely to prevail on its asylum arguments. That much flows inexorably from this court's decision in Huesha, which recognized that because asylum was discretionary, the executive could preemptively deny asylum to those that violated a bar on entering the United States. As Judges Millett and Katz has recognized, quote, this court held in Huesha that such a categorical and upfront rejection of asylum are permissible in emergency situations for a limited period of time, end quote. The stay panel further correctly recognized that the proclamation, quote, suffices for the Attorney General and the Secretary of Homeland Security to categorically pre-deny asylum applications that would be futile, end quote. This court should follow the path set by the stay panel and reverse on the asylum issue.
Do you have a sense of what the regulatory regime looked like in the immediate aftermath, the months aftermath after Huesha? And I guess to be more specific, Huesha said that the power to prohibit introduction included the power to remove, but it did say that withholding of removal rights endured, as well as cat rights. And it was pretty silent, I think, about what the procedures needed to look like for illegal entrants trying to vindicate their withholding of removal rights and cat rights. So do you have a sense of what procedures were used?
In post Huesha, so roughly in 2022, my understanding is that even before that decision, there was always some level of screening. It was less than expedited removal, but there was still some level of screening. The Title 42 orders, for example, had a humanitarian exception, and so there was a form of screening where questions are asked, and you're essentially directing those questions to answer the pertinent questions. And this court's decision in Hoisha made clear that the potential availability of statutory withholding or CAT were questions that, were pertinent and mandatory. And so that was part of the screening that was done. That was less than expedited removal, but it was part of the screening that was done. And essentially that sort of direct repatriation system that followed Title 42 is strikingly similar to what was used by, used after President Trump had this proclamation. And so this proclamation can be implemented in two ways: the direct repatriation, which is very similar to that Title 42 system, or expedited removal, but expedited removal as sort of modified by the proclamation, where, much like Hoisha, the access to asylum is not available.
Now, how do we reconcile the proclamation's ban on asylum with the rest of the INA? And I'm thinking particularly, for the example, there's certain provisions that mandate a credible fear interview, and they also establish judicial review for those asylum decisions.
Well, Your Honor, I think the reconciliation is much the same way that this court reconciled them in Hoisha, which is this court recognized that the discretionary nature of asylum was the way that could be reconciled. So this court in Hoisha said the best reconciliation of the two statutes is based on the discretionary nature of asylum. The executive may grant asylum or it may not. It's a matter of executive discretion. And
but in Hoisha, weren't you dealing with two conflicting statutes as opposed to a framework as we have here?
No, Your Honor, I think much the same way you're presented with a strikingly similar situation. In Hoisha, there was a statutory provision that created an introduction bar, and here you have a statutory provision that created an entry bar. And in many ways, our arguments are even stronger here. In Hoisha, this court acknowledged that Congress might have been clearer if it had used a word like entry rather than introduction when referring to the executive powers to prohibit individuals from coming here, end quote. But here in 1182F, Congress actually did use the word entry instead of introduction. And so, the result is even clearer here than it was in Hoisha, because whereas Congress used in this court's view somewhat less clear language by saying introduction and thought Congress would have been even clearer if it had used the word entry, it did.
How should we, I'm not sure that I'm following that, because you started your argument by saying that nobody contests the legality of the entry bar. Well, that's because the entry bar doesn't add anything, unlike the barricade or the in sale, and unlike the Trump v. Hawaii, where there was actually some additional foreclosure of entry. This is just parroting what's already in the law. It's not legal to cross the border between points of entry, right?
Your Honor, I disagree with the premise for two reasons. I think as to Hoisha, it was also the case that the vast majority of people arriving were already, could not lawfully enter the United States. Title VIII already barred their entry, and yet the court recognized that the additional introduction ban, which could have been considered superfluous or redundant to existing Title VIII, nonetheless granted those additional powers.
There was an additional entry ban that applied to people regardless of whether they were coming into a lawful point of entry, right? They couldn't come because they were coming from places where the government had deemed that COVID was spreading.
That was an
additional bar. And then you say, but here, there's an additional bar, but people can violate it with impunity. Well, they can't violate it with impunity. The INA already provides for removal and expedited removal. And so there's not impunity there, is there?
Your Honor, we think there's impunity in the sense that the people are coming in order to make an asylum claim, and they gain access to the asylum system by violating the entry bar and also committing an illegal entry. And so we think where that's your objective and you achieve it by violating the entry bar, that's the impunity in which I was referring. I think
that was true before the proclamation as well as after. Just to be clear, that you were not permitted, it was unlawful to enter the United States other than at a port of entry with the appropriate documents.
That's correct, Your Honor, and that would also be true in the Huesha case, where it was illegal for most of them to arrive at the United States between ports of entry.
But that prohibition was not specific to people coming across the border between ports of entry. It was saying we don't want people who have infectious disease, right? Because they're going to spread, the vectors of disease are going to penetrate into the communities and cause a public health emergency.
That's correct, Your Honor, as to that particular case, but preventing disease is just one facet of the national interest of the United States, and 1182F recognizes broader interests that can be effectuated by an entry bar, whereas Title 42 was a somewhat narrower effectuating the national interest solely with respect to public health. Nonetheless, it was an introduction bar and an entry bar. It's to make those effective, the principle is ultimately the same.
Isn't the main difference, I mean, I think that you recognize this in your brief, the main difference between this case and Huesha is that this case is entirely governed by the INA, and the INA provides for restrictions on entry, and it also separately provides for removal and expedited removal. And the removal and expedited removal provisions deem themselves exclusive. And that would seem to imply, unlike in Huesha, where the court was confronting what did the public health law mean for that emergency. Here, the emergency is one that's contemplated by the INA. And the rather than allowing people to come across with impunity, they come across and they actually face removal provisions. Why is that not a distinction between this case and Huesha?
For several reasons, Your Honor. I think, first of all, although the Title 42 order might have relied on a statutory provision in Title 42, it ultimately relied then on Section 1227, which is say Title 8, to render people removable. You could say at that point you were within the INA and you would be stuck with expedited removal or Section 240. But that isn't, and that was precisely the arguments that plaintiffs made in Huesha, and they failed. And this court unanimously held otherwise, that even though it was Title 8 that rendered them removable, the expedited removal and Section 240 was not necessary. That instead direct repatriation and a upfront categorical denial of asylum could be effectuated. I think a second important distinction is the context here. Whereas CDC is an agency, it has only those powers granted by Congress and nothing further. Here, the context is these are powers that are granted to the president, who has inherent Article 2 authority in order to expel aliens. It's a fundamental asset or aspect of sovereignty. What the Supreme Court said in the Noem case as to expelling aliens was, quote, "The right to do so stems not alone from the legislative power, but is inherent in the executive power to control the foreign affairs of the nation." End quote. And so I think that context, to the extent these contexts are distinguishable, I think that's much more favorable to the government here, because Congress was legislating against a backdrop where the president has inherent Article 2 authority to expel aliens, and you could never say the same of the Surgeon General or the CDC director.
Go ahead, Judge Childs.
I was going to say, it seems your entire argument is disconnected from the text of the INA. So I just want to address, let's go back to the text. If we're starting with the text of sections 1182F and 1185A1, that's part of the INA. And part 2 is titled Admission, Qualifications for Aliens, Travel, Control of Citizens and Aliens. So how are we going to get around that title and then rule that these provisions give the president removal authority when that's addressed particularly in part 4?
Well, several reactions, Judge Childs. I think the first important one to note is within the text of the INA itself recognizes the discretionary nature of asylum. And that was the key aspect of the Huesha decision. And so even accepting the premise of the question, asylum remains discretionary. And as this court recognized in Huesha, the government can effectuate an upfront categorical denial to make an introduction or entry bar effective. I think the second point, the language.
But don't you have the opportunity to actually apply for asylum and then it becomes discretionary on the back end?
No, Your Honor, as in Huesha, this court unanimously upheld the government's use of an upfront categorical denial that did not allow you to apply. It recognized that the back-end denial would make that futile and that the INA did not require that futile gesture.
But in Huesha, the court talked about the logic of the pandemic and recognized that under the statute in, quote, normal times, the same would not be true, that you couldn't make this discretionary categorical upfront denial.
Your Honor, I recognize there is some language to that effect, but I don't think that's controlling here in multiple respects.
I mean by in normal times, unless it means when you're just dealing with the INA and not the public health provision in Title VIII.
Well, certainly, I think normal times has a different meaning within Title 42. Within Title 42, the Section 265 provision, that was referring to non-pandemic times. But what if
Huesha didn't exist? I mean, then what would be your best argument? Because I'm not sure I'm persuaded that that case supports the point as strongly as you're suggesting it does.
Well, Your Honor, I think even if that case didn't exist, its logic and reasoning is compelling, which is that certainly as to asylum, the discretionary nature of it recognizes that the executive has authority to exercise discretion whether or not to grant it, where they have determined that to effectuate an introduction bar in Huesha or here an entry bar, a categorical ban is appropriate to effectuate it. This court upheld it. So admittedly, if Huesha didn't exist, I couldn't point to that. I could only point to the logic expressed in that opinion that the discretionary nature of asylum permits that sort of upfront categorical denial. I think this court, for example, generally requires exhaustion before an agency in order to present arguments to this court, but recognizes a futility exception. That's something that makes, very solid sense where an outcome is certainly known. We don't require people or the government to go through empty steps in order to reach a result that that will result inexorably from the rules of law that govern.
But I'm not sure that you ever answered the question when I asked you earlier about reconciling this with the INA that requires that credible fear interview and established judicial review for the asylum decision.
So, Your Honor, I think that's only true in some contexts. So judicial review is only available in Section 240 proceedings. Excuse me. Section 240 proceedings. It is not permitted under Section 235 expedited removal. As to expedited removal, there are 3 layers of review. You get an asylum officer, you get a supervisor. If you don't like the decision, you can get a de novo review by an immigration judge, but that's where it ends. With some limited exceptions, if you claim to be a citizen, for example, you can get habeas, but for the vast majority of people, including essentially all asylum seekers, there is not judicial review under expedited removal. And furthermore, under direct repatriation, as was in the case of Title 42, there isn't the administrative review either. And this court did uphold that in Huesha. And I think it's important to push back as well that the language they use to say the INA is exclusive, that language is limited to aliens that have been admitted into the United States, which is a term of art within immigration law of people that have been lawfully admitted to the United States. It doesn't even apply to people that have been lawfully paroled into the United States. And so for all or virtually all of the plaintiffs or aliens at issue here, they are not admitted aliens. And so that exclusive language would not specifically apply to them.
You are relying on Huesha to the extent that, I guess the question is there's a conflict in Huesha between the Title 42 public health emergency provision and the INA, which confers certain process for people seeking asylum. Here, you don't have that kind of conflict because the provisions that you're relying on as setting up the conflict with the right to apply are also INA provisions. So Congress made the judgment in coming up with a comprehensive scheme that to the extent that a right to apply for asylum slows you down and getting in removing people, that's a decision that Congress made. So it seems like Huesha, really the crux of the reasoning is this notion that we have these two different statutes and the public health emergency that the executive was responding to in Wisha comes from a separate statute, and the court really had to dovetail that statute and the INA. Here we have only the INA. And so to say there's a conflict is to say that you disagree with the way that Congress integrated these different provisions.
Your Honor, I disagree with that. I think for three reasons. First of all, in Wisha, Title 42 didn't say a single word about removing or repatriating people. Nothing. All of the power at issue that came to remove people in Wisha or under Title 42 came from Title 8. So to the extent that there was any conflicts, they were within Title 8. They were not exogenous to Title 42. Ultimately, everything had to be done under Title 8.
The question was, how broad did the Title 42 public health mandate carve? So it's, how far into ordinary INA processes and rights did the Title 42 Public Health Authority, displace or deal with that putative conflict? And you just don't have anything like that here. I understand your point about, the thing that Title 42 Public Health Authority was conflicting with was something in Title 8, but Title 8 doesn't conflict with itself is the other way of putting my question to you. And so how can you have that same dynamic?
Your Honor, I think there's two additional dynamics. One is that by Section 1182F, Congress recognized that the president was given the authority to create or, quote, impose entry restrictions in addition to those elsewhere enumerated in the INA, end quote. And so that power to create additional entry restrictions and to make them effective is something that conflicts with those other provisions of the same ilk
I thought you weren't relying on that before this court, that argument, that the 1182F entry restrictions include encumbering an unlawful entry with a shearing away of rights that someone who reaches the United States would otherwise have. I thought you weren't making that argument.
Your Honor, I think we have made that argument, certainly perhaps phrased somewhat differently, but we've always made the argument that direct repatriation is a way of making the entry bar effective. I would say one of our key arguments is that and this court recognized a similar rationale in Wisha, that to make there an introduction bar, here an entry bar effective, it's not a toothless tiger. The government can take steps in order to make that bar effective, and that's an element of statutory interpretation that Congress intends for statutes to actually be effective.
But the president has authority to impose extra restrictions through regulation. Isn't that the notice and comment regulation?
I don't believe so, Your Honor. I mean, the president is not an agency, and so the notice and comment rulemaking.
The agency would do that.
Potentially, it could be subject to the APA, but as to what's promulgated by the president, it wouldn't be governed by the APA.
So you're arguing under 1182F that when the president finds the entry of a class of aliens detrimental to the interests of the United States, he can suspend the entry of aliens of that class, right? CEG, Trump v. Hawaii. Or any class of aliens, or impose on the entry of aliens any restrictions he may deem to be appropriate. And that's the clause you're relying on. He can impose on the entry of aliens any restrictions he may deem to be appropriate. And you're saying, well, the restrictions would be restrictions on ordinary asylum and removal procedures?
Your Honor, I think we're relying on both aspects of it. And in part, it was much like Wisha, where in order to make a bar of introduction effective, the executive could take the steps of direct repatriation and cutting off access to asylum. Our argument is that under 1182F, similarly, the president to make a bar on entries effective can take those same measures.
I don't read, and I didn't think you were relying on this before this court, but I don't read 1182F to allow the president to add conditions or burdens on people whose entry has been suspended, but to suspend the entry of some, and if it is allowing the entry of others to impose conditions, for example, the documentation commission conditions that are also in the proclamation but not before us, right? So it doesn't make sense to me to say that you're suspending the entry and then you're imposing on the entry additional conditions, and that could mean or authorize that people whose entry has been suspended and therefore are entering illegally somehow have additional conditions on them, like you can't apply for asylum. Is that your argument?
Your Honor, it's one of our arguments. We think
Okay.
there's also an argument under the inherently discretionary nature of
That's the argument
asylum.
I thought you were really leaning on. The
the-
discretionary nature of asylum. Here, the president he delegates through the proclamation to the people who actually, by statute, can make the discretionary decisions, and that they have made the categorical upfront discretionary decision.
That's correct, Your Honor. That certainly within the asylum argument, and that has been validated by Huesha. I don't believe the president's powers under 1182F and 1185A are limited such that he couldn't also, take the steps necessary to make an entry bar effective, including defining consequences for violating it. But certainly as the asylum issue, the inherently discretionary nature of asylum is front and center as our arguments.
Do you not read the proclamation to foreclose asylum to people already in the United States? Because it's to people who came across the southern border unlawfully, not at a point of entry, and who are physically in the United States. The proclamation doesn't speak to foreclosing asylum to those people.
I think it does, Your Honor. I think it specifically prohibits their invocations of any provisions of the INA that would allow them to remain in the United States. And then it specifically cites section 1158 specifically. And so I think that does precisely that. I think that's actually far clearer than the policies at issue in Huesha. I also think there's also no dispute as to what the government's policy is here. There is a categorical upfront denial of access to asylum for all of those that violate the proclamation. And the questions here are, the legality of that bar. There's not a suggestion that, and certainly the district court didn't indulge in the APA claim as to whether or not that was written in the correct place.
So the reference to restricting access to provisions of the INA that would permit continued presence is in section 3, which is the section of the proclamation that talks about requiring medical information and criminal history documentation. But I don't see that language. Oh, no, it's also in 2 and not in 1. But I guess the confusion that I have is section 2, for example, is only speaking to entry, restrictions on entry. And people don't have the right to seek asylum before they enter, do they?
They cannot typically seek so from outside the United States.
So who can actually apply for asylum under the proclamation? Or are you saying there's a categorical denial of anybody?
As to anyone that has violated the terms of the proclamation in its entry bar, they cannot apply for asylum. For those that arrived at a port of entry and complied with its conditions, they potentially could apply for asylum.
And then you mentioned 1182F and 1185, with respect to removals. If we were to not agree with you there, are you still going under Article 2 as an independent basis for the president's authority as to the proclamation?
Your Honor, I think Article 2 is more important in terms of construing the scope of the grant of Congress's authority, as well as it underscores, the discretionary nature of asylum and is again supported by the fact that ultimately these decisions are the sort that fall within the context of the president's inherent Article 2 powers.
You assume that the executive may make and has made an upfront categorical decision to deny asylum. What is your argument that prevents non-citizens who are physically present in the United States from applying? The statute gives a right to apply even to people who are statutorily ineligible for asylum. So the futility argument seems to me Congress addressed and rejected. So what is the argument that right, it seems like a pretty durable right that the last administration and that the first Trump administration recognized was a right that could not be swept aside by executive action, that now you're saying that it can be?
Your Honor, I think it's exactly what this court recognized that, where because an asylum decision, quote, has already been made, end quote, allowing them to apply, it would be futile. And thus it could be validly cut off because the law essentially doesn't require the empty gesture of allowing people to file applications that are ultimately doomed to failure under the governing law and the standards that would be applied to them. And so we think that that logic is ultimately controlling here.
I have in my head three different kind of powers, and I've struggled a little bit with how much they overlap and how much they don't overlap. One is an 1182F power to remove. The second is an 1182F power not only to remove in a general sense, but to remove in a specific way that conflicts with 1225B1 and 1229A. The first is, can you remove? The second is, how do you remove? And then the third, which I don't want to talk too much about, is the substantive protections of withholding against removal and CAT protections that regardless of the procedures that lead to them being vindicated, some people are going to want to try to vindicate if they can. So you can just scratch the third one off. I don't have a lot of questions about it. Those first two, again, in Wisha, they kind of got bled together a little bit, I think. And here I'm wondering, are we talking about the same thing? Does the government want, I know the government wants both, but what would it look like to give the government the first and not the second?
Well, Your Honor, I think that's accurately describing the current system that's existed since this court's August order, where direct repatriation is subject to an injunction of the district court, but expedited removal without access to asylum is currently essentially what is being applied at the southern border right now. And so certainly those two issues are distinct, and I think we are on the strongest ground, certainly as to cutting off access to the asylum system. And, certainly that's how the state panel, kind of resolved those two questions. I think that in that second category of expedited removal, but expedited removal without access to asylum, the government has both all of its powers under 1182F, plus the additional inherent Article 2 authority, and then as well as the inherently discretionary nature of asylum. And so I think you have all of those for the government in that context of expedited removal, sort of as it's existed post-August. As to direct repatriation, that is something that we think is also supported by Huesha. I mean, that this court thought was could be done to effectuate an introduction bar and implicitly recognize that language permitting an entry bar would be even better for the government. And that is what we have here. But certainly we think we're on, the strongest ground as to how essentially the state panel resolved this.
Okay, that's helpful. Imagine the court were to resolve a few issues I'm about to go down in a certain way. It's going to have some follow-up questions about what that would look like and some, I think, lingering questions after that. So imagine that the proclamation can bar asylum applications, as you say. And it includes the authority to bar entry includes a general authority to remove. But when it comes to how to remove, 1225B and 1229A still control in terms of the procedures that people resisting their removal are entitled to. And in those procedures, they can assert substantive rights that the proclamation did not have the authority to eliminate. And those two substantive rights are withholding of removal rights and CAT rights. Also, there's no class injunction because of 1252F, but there is declaratory relief because of our precedent in Make the Road. And there is APA vacatur with regard to, I guess, the guidance, but probably not the proclamation. Okay, so that seems to describe something pretty similar to what exists now and since August. And I guess, there's a lot of parts of your brief that seem to say, you really, really need to win on all these issues, or, we're going to go back to 8 million people crossing the border illegally. It doesn't seem like that's going on since August. So I guess maybe this is a pretty open-ended question, but I have some specifics afterwards. What do you think that regime would look like that I just described?
As you've described it, Your Honor, that is essentially what has prevailed since August. That does eliminate the government's ability to do direct repatriation, which I think was certainly very important in getting the crisis under control. Now we are in a somewhat different circumstance where the administration has successfully brought control to the southern border for the first time in a generation, and so that does. And I'll caution, much of this is not in the record because the post-August obviously is after the record closed, it's after final judgment. But the public data is that the number of encounters have stayed at historical lows. It is within the government's capacity to conduct expedited removal. Part of the reason the crisis became so bad in the Biden administration is the number of arriving aliens was so large that it exceeded the ability of the government to process them under expedited removal, and hence they had to be issued notices of appearance or paroled in. That is something that is no longer the case at present. I think the nature of that crisis also underscores why the president's authority. Good.
I mentioned 1252F prohibiting a class injunction, as you argue. Unclear to me if CAT is covered by 1252F. And the reason is, as the plaintiffs argue, that 1252F covers, and now I'm quoting from your brief about the actual statute, it covers Chapter 4 of Title 2 of the INA. CAT, I think, is not part of the INA. CAT is part of FARA. So it seems like maybe 1252F1 does not prohibit a class-wide injunction when it comes to CAT.
Your Honor, I disagree with that, but I think there's two different contexts, and so the arguments for why it applies in each context is different. As to direct repatriation, the CAT regs wouldn't apply by their terms. They only apply to Section 235 and 240 removals. There is CAT screening within direct repatriation, but it's plaintiffs argue that it violates the reg, but the reg doesn't apply to direct repatriation. So there isn't a 1252F issue there. There's just a merits issue. As to how it operates within expedited removal, then you are squarely within 1252F1 because you are, because that is effectively seeking to enjoin how expedited removal is being operated. If you disagree with how CAT screening is being conducted within expedited removal, that's exactly the sort of injunction that requires the operation of expedited removal in a different manner than the government is operating it. And so that's squarely within.
I'll think on that. That's helpful. Do we need to decide the size of the class if 1252 F1 prohibits a class-wide injunction?
I don't believe so, Your Honor, in that I haven't specifically given that thought, but my intuition is that if 1252F is barring relief to non-class members, then the size of the class may not be a particularly
barring injunctive relief, but there's a chance it would still allow for declaratory relief. And also there's the APA suit. I take it the APA doesn't need a class because one person can sue to vacate regulation. But on the declaratory relief issue, if you lose on that, if we conclude that Make the Road allows class-wide declaratory relief, then would that mean we do need to address the size of the class?
Your Honor, I'm not sure offhand because the nature of declaratory relief is such that I'm not sure that it terribly matters who specifically it applies to. I do think that if it were conferring any rights that could be exercised by class members, then you would be squarely presented with the TransUnion issue, because then it becomes an issue of the authority of the courts to issue that relief. And in that context, TransUnion makes quite clear that you cannot issue, that class cannot be any broader than people that every single one of them possesses Article 3 standing.
Then I'm coming to an end here. I appreciate your patience and my colleagues' patience. There are individual plaintiffs who the stay order did not provide relief to the government with regard to the individual plaintiffs, I think. So I have that basically right.
I believe that's correct, Your Honor. It took effect immediately, and the district court kind of severed its two things.
In other words, the district court's injunction survived the stay panel unscathed with regard to the individual plaintiffs.
I believe that's correct, Your Honor. I'm not even sure that we sought relief as to this day on that.
Do you know if they've received complete relief? Or are they still in removal proceedings, or what's the status there?
Your Honor, I think it's a mixed bag. I'm not sure offhand. I think they were in different categories. Perhaps opposing counsel could speak to that, but I don't know the precise status of them.
And even if they had received complete relief, the case would not be moot in any event because of the possibility of associational standing. Is that correct?
I think it wouldn't be moot, certainly, because even if they had received complete relief, this court could undo it. And the possibility that they could do so would provide a form of effective relief that would preclude the mootness inquiry.
Okay. Thanks a lot for your answers.
If I may, one quick housekeeping matter as well. To the extent that this court is inclined to dissolve any aspect of its stay that is currently in effect, we would ask that the court delay the effective date by 14 days. The enormities and complexities of border management are such they can't be kind of turned on and off like a light switch. So we asked the district court to delay it for 14 days in order to seek an orderly stay. In that instance, the district court granted that request. We would make a similar request of this court to the extent that it would vacate it, any aspect of its stay. Of course, our request is that you reverse the district court's judgment in its entirety.
All right. We'll hear now from Mr. Gallant.
Good morning, Your Honors. May it please the court, Lee Galern from the ACLU for plaintiffs. I'd like to, if I could, just jump into the conversation that Judge Child was having with my friend about the INA and reconciling the INA. I think that's the whole case here, really. It's that This is an internally coherent statute, which Congress has put together the pieces. And what's ultimately happening here is that the administration doesn't like the way Congress has put together the pieces, but Congress has put together the pieces. And so if I could, I'd like to put a pin in Huisha for the moment and come back to that, but explain why the proclamation is not permitted to bar asylum, because I think that's where sort of all the action is about asylum, or at least to start with that. So the government has toggled back and forth throughout the litigation between two theories. The first theory is that 212F itself allows the government to override asylum. They've now, in this court, as Judge Pillar has pointed out, sort of switched gears a little bit and said, well, it's not that, it's more the nature of asylum being discretionary. So, but let me talk about both of them. 212F cannot override asylum for many reasons. 212F speaks to the ability of the president to bar entry. And indeed, the executive branch has consistently taken the position for 4 decades, back to Ted Olson's opinion for OLC, saying 212F doesn't override asylum. And indeed, where Congress wanted to say an inadmissibility ground, meaning a ground in which people can't enter the country, can override asylum, they expressly said so. So they expressly said in the asylum statute that one of the inadmissibility grounds dealing with terrorism, which makes sense, would override asylum. But 212F itself cannot override asylum. That's never been the executive branch's position. In fact, just last year in 2024, they put out a regulation and a long Federal Register discussion saying 212F cannot override asylum. So I think this court ought to be very wary about finding that power in 212F against the consistent position of the executive branch, where Congress has chosen to reconcile the statutes. And indeed, as Judge Childs pointed out, the asylum statute is very clear. It says you may apply if you're in the country, irrespective of your status. So it doesn't matter how you came, what your status is. It says whether or not at a port of entry. And so understandably, I think that's why the government has abandoned this notion that 212F itself can override asylum. And so what they've switched to is, well, the discretionary nature of asylum allows the president to override all of asylum and not allow you to apply at all. And so the first point I want to make is what Judge Childs said, is that discretion goes to the back end. And there, it's just to this point about discretion at the back end being in individual cases, it's almost never the case that someone's denied asylum on discretionary grounds, only where there's something extreme, and there very much is review. And if you look at 8 U.S.C. 1252 A2 capital B, little Romanet 2, it actually exempts asylum from a bar on review of otherwise discretionary claims. But I think the more fundamental point is that the discretionary nature of asylum does not allow the president to enact this categorical bar. And the reason is threefold. One is 1158 is explicit that it can, if you want to add a new bar, it has to be by the agency, either the Attorney General or the Secretary of DHS. The second point is it says it has to be done by regulation. And that's no small thing, because eliminating asylum is an enormous step. And so at least when there's a regulation, it's subject to arbitrary and capricious review. People can weigh in. The third reason is the most fundamental. The statute 1158 expressly states that any new bar, even if added by the agency and even if by regulation, must be consistent with the asylum statute. And Judge Bybee in his East Bay case goes through this very clearly. And what that means is you can't have a bar that essentially wipes away everything that Congress has done. So a categorical bar by an agency, by regulation, saying murderers can't get asylum might be consistent with the asylum statute. But a bar like the one the president has enacted, even assuming the president can do it without regulations, is plainly not consistent with 1158, because what the proclamation says is you cannot get asylum if you've entered illegally or without documents. But the statute, as I said, expressly states You are entitled to apply for asylum irrespective of your status and whether or not you entered at a port, as long as you're physically on U.S. soil or arriving at U.S. soil. So there's
Now, could the executive lawfully accomplish the same end results and objectives of the proclamation by promulgating regulations, or would that even be unlawful?
That's a very good question. And even that would be unlawful. You know, as you're absolutely right. It would first have to start with a regulation by the AG or Secretary of DHS. But then for that third reason I mentioned, it would still be unlawful because it would be inconsistent with 1158. It would effectively wipe away the statute. So Congress made a very, very considered decision to say, we are going to allow you to apply for asylum if you get to U.S. soil, regardless of how you get here. And the statute expressly says whether or not at a port of entry and quote unquote, irrespective of your status, we are going to allow you to apply for asylum, even if you've entered illegally. And the reason is because Congress understood, consistent with international law, that people fleeing do not always have their papers, cannot always come lawfully, cannot always find a port of entry, cannot sit in their home country to wait to get papers. And so they get here any way they can. And that's why Congress could not have been clear in 1158. So that's why, and the statute, moreover, as I said, says any new regulation, even enacted by the agency through regulation, must be quote unquote consistent with this section. And so a proclamation, or in your case, to your hypothetical, a regulation that says asylum is not available simply because you came here illegally or without papers would be absolutely inconsistent. And I would recommend to the court Judge Bybee's decision in the East Bay decision where he goes through all this. And in fact, the regulation that he struck down, to your point, Judge Childs, about whether it would be consistent if it was done by regulation, he had an even harder regulation before him that he struck down because that went to eligibility, not the ability to apply. And the government said, well, we're still letting you apply. We're just going to deny you eligibility. And he said, well, that's a false distinction. But here they've even skipped that step and said, we're outright not going to let you apply, even though 1158 specifically says you may apply. And there they cut off asylum only for people between ports. This is broad-based, to your point, again, Judge Childs, about who does this affect? It affects everyone who's coming. And a lot of people say to me, well, what about if you come to a port of entry and it's clear you're going to be discriminated or persecuted on the basis of your religion or something like that, and you have overwhelming evidence? Nope, the proclamation doesn't even allow that. So this is...
If individuals are still allowed to apply, would it be your position that the government could then lawfully use its statutory discretion to deny every single asylum application?
No, absolutely not. I mean, so first of all, you're right to point out that application and eligibility are in different parts of 1158, the asylum statute. This says you can't apply. So right there, it expressly violates the terms of the statute. But if they were to say, well, we'll let you apply, but then deny it anyway, that would be exactly what Judge Bybee talked about. That is basically wiping away the statute to just play games. That's formalism. I mean, that's, you know, sort of a formalist over a substance kind of distinction. So absolutely not. The point of the statute is people are in danger. I mean, we have people who are fleeing Egypt, Turkey, the Taliban. The point is to at least allow them to apply and have their application considered. There's no question, based on the Board of Immigration Appeals decision in matter of PULA, as Judge Bybee discusses, at the very end, as you pointed out, Judge Childs, there could be some discretionary element. But what's absolutely notable about the matter of PULA decision in the BIA is it said, the mere fact that you came here illegally can't be dispositive, even at that back end on discretion, even in an individual case, because that would make a mockery of the statute that says you're entitled to apply for asylum and be considered for asylum, irrespective of your status and regardless of how you came. So I don't think that this bar can stand regardless of which theory the government's ultimately relying on now, whether it's that 212F overrides or that the discretionary nature of asylum is sufficient. And so if I could, I want to turn to Hawisha. Judge Walker was obviously the author of that opinion. I argued it. We had a long back and forth about that during Huisha. I think there's many differences in Huisha. The primary one is, of course, what Judge Pillard and which Judge Childs pointed out is there you were expressly reconciling two different statutes and made a significant point about how the best reconciliation at that point, and as you said, it was a tentative decision, for that reason alone, I would counsel that it's appropriate not to expand Huisha. But we're reconciling a statute outside the INA with the INA that had different language in different circumstances. Indeed, as Judge Pillard pointed out, was sort of discussed as in normal times, things might be different. And notably, I don't know if Judge Walker remembers this, I'm sure not, but the government said to Judge Walker in its briefs in Huisha, our interpretation of 265 is irrelevant to how you interpret 212F. And indeed, that's because I think consistent with their position over 4 decades, they had said 212F doesn't override asylum. So we see no basis for Huisha to control this case. And certainly, given the tentative nature of Huisha, I would leave to the panel whether Huisha is technically binding, but it certainly was expressly tentative. The other point I just wanted to make is what my friend said when he first stood up, which I think Judge Pillard has already addressed, is that this is not about letting people get on U.S. soil and then giving them impunity. Our position, just to be very clear, is you get on U.S. soil, you can still be removed. You're still inadmissible, just like any of the other inadmissibility grounds in Section 1182, 1182A, 1 through 10. All those grounds of saying you can't come in, if you get into the U.S., all those grounds allow you to be removed. The same thing with the 212F proclamation. We're not saying you get onto U.S. soil and you have impunity, you can't be removed. We are simply saying, and I think Judge Walker was asking my friend about this, that you have to use the procedures in the INA that's in Section 240 and the ER procedures, and you have to provide the substantive protections that Congress has provided. And I want to correct one thing that my friend said. He said that 1229A only goes to half of whether it's inadmissibility and deportability. 1229A expressly applies to anybody who's either deemed inadmissible, which these people would be, or are deportable. So that's the statute Congress wrote and prefaced it with, this is the sole and exclusive process for removing people, but for something that's specified in the INA, which is the expedited removal statute.
Do you agree with Mr. Inson's description of the kind of practical effects of Huisha in terms of what facts looked like on the ground for the
Yeah, so we did try and get to the bottom of exactly how it was interpreted. I mean, as you already know, ultimately Judge Sullivan vacated it on different grounds and it ultimately went away. But at the time, it basically allowed the government to push people back to Mexico. They were supposed to give them a screening for withholding or CAT. Those screenings did not generally occur because they used what was called the manifestation standard, which I do want to touch on briefly if I have time at the end, which basically said people need to know to say they're in danger and ask for a screening. But basically, I think I agree to the extent I understood he was saying is they could still remove people without any process. But if the person asked for a fear screening, they would get a screening for withholding or convention against torture, but they had to know to ask for that. And otherwise they would be repatriated without any process.
And that looks pretty similar to how things have looked since August, right?
Well, I think the difference is that the state panel made clear that the removal process does have to be used either 240 or ER. I think, you know, you're right. In Huisha, you didn't spell out what process had to be used. You did point out that expulsion can happen under Title 42. And the reason I think you had to point that out, which you don't have to hear, is that we argued very strenuously that once you got onto U.S. soil, Title 40 didn't apply any longer. And so I think that's what the discussion you had in Owisha was designed to. Here, we're not saying 1182F doesn't apply once you get on U.S. soil. You just need to use those processes. And 1182F, of course, comes with companion provisions for removal, where you were trying to reconcile a unique statute from way outside the INA.
So would it be fair to say that in the months after Owisha, before the district court would have vacated, the facts on the ground were not as good as you thought they were going to be?
I think they were bad for us. I think people were being removed without any screenings whatsoever and were put in real danger. And I do want to your point, I don't know if you had a follow-up, but I just wanted to make one quick point for the whole panel here. The government is obviously saying even withholding it cannot be used. They apply only CAT and only if you know to say I might be tortured. The reason we're making such a big deal about asylum is that largely the whole ballgame now is asylum. So withholding gives you protection against persecution, but it's a very high bar to meet. But the critical aspect of withholding is that it only stops you from being removed to your home country. You can still be removed to a third country. What's happening now under this administration is they're saying, okay, we can't remove you to your home country. Maybe that's Colombia. We're going to send you to West Africa, or we're going to send you to Asia. Or we're going to send you somewhere where you have no connection whatsoever. Asylum, on the other hand, what Congress was very explicit, asylum does not allow you to be removed. It allows you to get your family in potentially if they're eligible, and it allows you ultimately to apply for permanent residence. Without asylum, I fear that even if people are given withholding, they're going to be sent to far-flung places all over the world. So for us, that's why asylum is so essential beyond even any protections that withholding of removal or the Convention Against Torture would give.
Can I ask you some questions that go to remedy?
Yeah.
The APA vacatur would cover the guidance, not the proclamation. Is that correct?
Correct.
Okay. And you don't really need a class to vacate the guidance.
No, we don't.
What about for declaratory relief? Is there a point to that being a class, or do you not need the class for that as well?
I think a class would be important there. Otherwise, I think people would have to come in and bring individual cases to assert their rights. I think that's going to be very difficult in a situation like this with people at the border.
Class is pretty broad, and there's some debate in the briefs about whether you and the government are even disagreeing about whether we should change the class as it existed after the state panel. But I think the government would say that after the state panel, the class still covers people who are not here today, but will be here tomorrow. And they don't want that. And I think you're saying you agree that that's what the class as it exists post state panel covers. Is that right?
It would cover someone who, once they get to U.S. soil, they become a member of the class. And I think that for us is critical. It's a little difficult to, and that's what the state panel did. You're right, to clarify it. And it's a little difficult to understand whether the government opposes that, but I think they do oppose that.
I mean, I could see why. I think that means someone who, when the final judgment is final, is, imagine someone in the Amazon jungle who's had no contact with, anyone outside their tribe. I mean, the district court has issued a class-wide injunction that covers someone that far removed from people with actual imminent injuries.
Well, I think it's not that different than a normal class that has future members. So Your Honor is positing someone who may never come here, so then they're never going to get the protections. And obviously, if years from now the government wants to go back and say the injunction's been in place too long, then
but hypothetically, if that person did tomorrow learn about the United States and come here, that person would be protected by the class-wide injunction.
Well, they would, and I don't know if Your Honor is positing a situation where the only reason they're coming is because of the ruling.
That person is so unlikely to be injured they can't possibly have standing, and yet you are defeating.
Well, I think they would, yeah, I'm sorry to interrupt.
It's okay.
No, I think they would have standing once they got here, and I think that's no different than any kind of class that has future members. So if they never decide to come, no harm, no foul. If they
They're
come,
not actually a part of the class because they're not
right,
part of the class unless
exactly.
they come, they have it. But for the proclamation and guidance, they would have an intention and a basis to
Exactly.
seek asylum, withholding, cap protection. So it's not people in the world who will never come or
Right.
aren't being persecuted. But there is this problem with whether in TransUnion saying you have to have a current imminent harm where you can't be in the class. And I mean, I think you're right that in many injunctions in the past, they've had this nature of when you come and
Right.
and you develop standing, then you are in the class. But I think, I mean, Judge Walker can follow up, but I assume he's asking about, more recent law that suggests maybe you can't.
Yeah, I think the law is still down. We don't understand CASA to change this, that you can have future members. Now, I think Judge Moss on remand could decide whether someone who doesn't get here for years, but the problem for Judge Moss, I think, is you have someone who's in real danger. They're going to come 2 days after the decision, assuming you uphold the decision. They have to be a member of the class once they get on U.S. soil. And so, I do understand, and it's fair, Your Honor is asking about someone who's in the Amazon who may never come or could come 5 years from now. But I think Judge Moss on remand could handle that. But it can't be that no one is not on U.S. soil right now would not be part of the class. And indeed, we have people who are on U.S. soil who were removed. Judge Moss put a pin in that for another time. But it can't be, I think, that we have to come back to court each time someone comes to the U.S. I mean, that would be unworkable, I think.
So I think well, go ahead.
I was going to move on, so please.
Well, what the government says is a court may not certify a class that would sweep in uninjured, absent class members, people who are yet to be perceptibly harmed, and then quotes TransUnion, Article 3 does not give federal courts the power to order relief to any uninjured plaintiff, class action or not. So I think the question is whether the government is reading that to say you can't include them in a class.
Right.
Because that would be ordering relief. And maybe is your answer that, well, they wouldn't be ordered relief because.
Well, that's exactly right. They're not entitled to anything until they become part of the class, and they don't become part of the class until they step on U.S. soil.
And those were in that situation, it was about relief, not about class membership, but they were, half the plaintiffs were people whose information had been made public, and others where it was just erroneous, but in the files of the credit bureaus. So, all right. You had other questions.
The government said a few minutes ago that CAT should be considered in Chapter 4 of Title 2 of the INA for 1252F purposes because it's part of what would be required in the removal proceedings that are required in Chapter 4 of Title 2 of the INA. Do you have a response to that?
Yeah, I think that proves too much. I mean, if that's their position, then presumably asylum would also be, and they haven't made that argument with respect to asylum. But I just taking a step back about 1252F1, I think the government's argument ultimately proves too much. The government, Judge Moss essentially said 1252F, proclamation is ultra virus from 1252F. 212F does not authorize the proclamation. So there's an ultra virus problem. The government's now saying, because we can't use 212F, we're now left with the INA. And therefore, you're essentially telling us to use the INA. That can't be right. That would essentially make 1252F1 limitless. The president could say, I refuse to use any part of the INA. If this court said, well, you have to, you can't just say, I'm going to remove people, I'm not even point to a statute. The government could say, well, now we're forced to use the INA.
I follow. I mean, I thought their part of the briefing was well done and your part of the briefing was well done on that issue. I think I understand the arguments there. I'm not sure I totally followed your proves too much with regard to CAT specifically, because you said, well, that would mean asylum is covered, but asylum is covered by 1252Fs. Just go.
Well, asylum is outside of Chapter 4 as well. That's the only reason I was making that point. If the government's saying, because CAT is outside of Chapter 4 as well, and so the government's never suggested, and it couldn't possibly suggest that asylum falls under 1252F1. And I don't want to be suggesting that both asylum and CAT should fall under 1252F. I just think neither does. I think there's the more fundamental problem that we are challenging 212F, and that's obviously out of Chapter 4. I would urge the court, if it's interested, to look at the government's stay application in the DVD case, which Judge Moss cited, which explains their real position on 1252F1.
Government had something in their brief along the lines of, you've not identified any statutory provisions of the INA or statute implementing CAT that contradicts the procedures set forth in the guidance with regard to CAT. I'm sure you disagree. Maybe can we phrase it a little differently? Was it?
Well, I think the regs were passed pursuant to CAT. Those regs have never been challenged. They're lawful. And I think what the regs do are two things that I mentioned, which are very important. And I would note that the government is not following the state panel on this and not applying the regs. The regs require that there be a significant possibility standard at the expedited removal stage, at the credible fear interview stage, not the ultimate high burden of more likely than not. And that's the 208 reg. I think it's 208.30, because you can't be expected to meet your ultimate burden at the border without any help. And the other reg, which is critical, is in 235, I think it's 235.50, which says you have to advise people of their rights and specifically ask them whether they have fear. And so those are the two regs. They've both been passed pursuant to the statute, one pursuant to the expedited removal statute, one pursuant to the asylum statute. And so I think that Judge Moss was absolutely right to say 212F can't wipe that away.
So those are the regulations, but there's not a statutory provision that the summary removal procedures conflict with. It's those two regulations.
That manifestation standard. Well, there's a significant possibility statute that applies to asylum. It doesn't apply to withholding and CAT, but those two regs have been in existence for a long time. The government's practice has always been you have one credible fear interview. The significant possibility standard is applied to asylum, withholding, and CAT pursuant to that regulation. And the government's consistent practice has been that you advise people with a Form 867 that Judge Moss laid out saying, do you have a fear? Would you like to have a screening for that?
So I think your answers to me and to Judge Pillard's last question confirm that the government sentence is correct. It doesn't necessarily mean they win because their sentence is not talking about any regulations. Their sentence says, I don't have the exact sentence in front of me, but something along the lines of no statutory provisions of the INA, no statute implementing CAT contradicts the procedures set forth in the CAT guidance.
Right. On the point about manifestation and the significant possibility, those are not statutory, those are regulatory, but they are longstanding pursuant to, I know I'm just repeating myself, pursuant to those statutes.
I thought you just said there is the significant possibility.
There is for asylum.
Standard for asylum in the statute.
Yes, in the statute. I'm sorry. I apologize. I thought Judge Walker was specifically asking about CAT.
I was, but yeah, to get it all covered.
Okay.
Yeah. Mr. Ensign was, I just lost it, but was talking about a protection that was only applied to people admitted into the United States, not people paroled. And I lost track of what that was and what.
I think he was raising the entry fiction doctrine. And the entry fiction doctrine is a constitutional doctrine for purposes of due process. Whether someone stopped at the border and paroled in is entitled to the same due process rights as someone who's been admitted or maybe here unlawfully for a long time. And I think Judge Walker cited that doctrine in Huisha. That doctrine has no relevance to the statutory claims we're making here. We're not making a due process point. We are making only a statutory claim. And I think Judge Walker and Huisha rightly distinguished the entry of fiction doctrine as to constitutional claims with what statutory rights Congress may give you.
1231H, put aside the forfeiture issue.
Yeah.
I think I follow their argument. What's your argument in response?
So our argument is that it simply doesn't give you an independent cause of action under withholding, but it doesn't mean that you can never challenge a withholding restriction based on sources of law outside of that of withholding. So in our case, obviously that you can't wipe it away with 212F. And that's, Zedvitas talks about that. The government rarely cites that provision. And when it has, it's been rejected. But it's
what's the source of law that the plaintiffs are relying on to challenge withholding removal? Would it be that APA and the guidance is
right? Well, that withholding is there unless it's taken away. The government has tried to take it away using 212F. 212F doesn't allow you to override withholding. And I think that does follow from Hoisha. That was obviously an even harder case.
So it's like you can't vindicate a 1231 right, but you can vindicate an 1182F right. When the 1182F is talking about what the president can do, not what you're entitled to.
Yeah, but I think we read H, and again, I don't know any court that's ever accepted the H argument when the government sporadically makes, and I think Zedvitas deals with it pretty firmly, the Supreme Court's decision in Zedvitas, that it just doesn't give you independent rights beyond what withholding does, or allow you to have an independent cause of action and go into court and say, I want withholding and here are my rights, the classic independent cause of action. But you obviously can go in and say, I want withholding, and it's been unlawfully taken away.
So the argument about ex ante categorical exercise of discretion, which seems to me really the core of their position, to the extent that they are not really relying on 1182F. They're looking at wisha, they're saying
right.
Emergency there, emergency here. Yes, the INA is a fully integrated statute and has removal and has expedited removal, but didn't contemplate the level of dysfunction, the level of flooding of the border that we've had.
Yeah.
And so if ex ante categorical exercise of discretion was available there, it's available here. And if it is available, then the right, no matter what, to apply for asylum also is futile. And it's futile in a different way from in some of the other situations where even to know whether someone was disqualified from asylum, you'd have to look at an application to know whether they're in that group or not. I think the government's argument would be, well, this is different. This is more like wisha, where it's just everybody, anybody, they're wanting to ex ante in an exercise of discretion, prevent from coming, and therefore it's sort of running the Bybee logic the other direction and say, we're not going to give you a right to apply because we're not going to give you the asylum, just so when Bybee says like, oh, you have a right to apply. Well, if you're not ever going to get the asylum, the two should travel together. Here, I think the government is saying they travel together, and the answer is no. What's your best answer to that?
Yeah, I think a few things. One is I want to just put a pin in if we have time to come back to the question of there's this crisis here and the proclamation has solved it. Well, let me just address it really quickly, but I don't want to fight on that ground because nothing in our argument hinges on whether the president has correctly said this is a crisis or not. But I would recommend the Cato brief, the amicus brief written by Cato, that points out that by the time the proclamation was actually passed, the migration flow had been reduced by 90% from the highs during the prior administration. It also, I think the fundamental answer is, of course, this just illustrates that the president doesn't like what the scheme that Congress has created. So the answer is to go to Congress. But to your more precise question, I think the answer is I don't want to sort of beat a dead horse, but is back to 212F can't override asylum, that this is a coherent statute, that Congress didn't anticipate that 212F would do anything more than allow the president to bar entry. And you look at Hawaii v. Trump, that's what it's about. It's about barring entry, creating new inadmissibility grounds. And indeed, the government has used 212F 90 times in the past, along with OLC memos. It is never suggested, in fact, it's concluded the opposite, that it can override asylum. Now, to the discretionary point, I think that ultimately comes down to Congress having directly addressed it, and different than OISHA. And to your point that this is an internally coherent statute. So the proclamation talk is based on the criteria as you came illegally, you came without papers. But Congress anticipated that, was expressed that it doesn't matter your status. They know people are going to have to flee in danger and get here. It doesn't matter where you enter. They know people can't always get to a port of entry. They won't have papers. So they expressly addressed that. And then they said, you can add bars, but they have to be consistent with the statute. And I think Judge Bybee's point was, if your bar says you're not going to be allowed to apply for asylum or ultimately obtain asylum because you came here illegally or without papers, you're wiping away the statute. But the statute says that the bar has to be consistent. I would also just go back to my other points about the president can't do this. The statute, again, was explicit. It has to be by regulation by the agency. And I think that's for good reason. Wiping away asylum is such an enormous step. I mean, we made a solemn promise after World War II. We would never again send people back to danger without at least a screening. So Congress has said, if you want to try and enact an upfront bar, it has to be by the agency, and it must go through notice of comment. It must be a regulation that allows people to push back. But again, ultimately, the fundamental difference is you can have a bar by the agency if it's consistent with the statute. The example I gave before, you're going to say no murderers can get asylum. But you cannot do something that's directly inconsistent with the initial words in the asylum statute. Everyone may apply, irrespective of status and whether or not they entered at a port.
You're not challenging the provisions that you have to bring. If you come to a port of entry, you also have to have documentation of your criminal history and your health.
We are, Your Honor.
Case.
Well, I think it is. I think that the Judge Moss struck down the proclamation. I think it's part of it. And I think the reason that's unlawful is because that also sort of is inconsistent with the asylum statute, because Congress did not require people to bring papers with them. You know, that's why 212 is ultimately about stopping entry, and particularly people with visas who've already done their paperwork overseas. They expected asylum seekers to show up maybe with just the clothes on their back, no papers. So requiring them to bring papers would be inconsistent with the statute. The very thing Congress was trying to do is say, you're here unlawfully, and we can remove you if you don't ultimately get asylum, but you're going to be screened for asylum because you made it to U.S. soil and you're claiming you're in fear.
And then kind of turning over your answer on the need for a class in order to vindicate the declaratory relief. And I think what you said is, absent a class, then each individual person would have to sue to vindicate that declaratory judgment. But that really, really makes it sound like an injunction. And I think you need it to not be the exact same thing as an injunction, or else it's covered by 1252F.
Well, so I think a couple of points. You know, those are fair questions. One is, if the vacator stands, that makes the injunction less important. The reason the injunction is important, I just want to make this clear.
You mean declaratory?
Yeah, I just meant more relief than the vacator. I'm sorry, I misspoke. The vacator should have been enough, but the government said to Judge Moss, even if you vacate the guidance and the agencies don't know what they're doing, we're going to enforce the proclamation. So Judge Moss said, well, then I need to issue the injunction. On declaratory relief, I think this court has already said in Make the Road, you can have declaratory relief in a class. So what I'm saying is, that you can have individual injunctions. If there's a declaratory class-wide relief, then each individual can then use that to come into court and say, well, I was part of this class. And 1252 F1 doesn't speak to an individual
How would
coming in
that be
for an
different than
injunction.
if there was an individual plaintiffs who obtained declaratory relief and then other people came into court later and said, give me an individual injunction based on that declaratory?
That's a fair question, and we're happy to brief that. I'm not sure as a practical matter how different it would be, but I think it would be different in coming in and saying I was part of this class. It may require an entire new case and to brief everything from scratch. So I don't know whether as a practical matter, and I apologize that I may not have given it enough thought to know exactly the practical thing. But I think I think we would stand by the need for a class-wide declaratory. We don't think that Judge Moss abused his discretion in doing that in light of Make the Road.
All right.
Thank you.
Thank you. Back.
Thank you, Your Honors. If I may, just 4 quick points. First, all of the arguments that plaintiffs have made about the supposedly non-discretionary nature of the right to apply for asylum are arguments that could have been and were made to this court in Huesha, and this court unanimously rejected them. We think that same result needs to obtain here, and nothing has changed in the interim. Second, plaintiffs' arguments would leave the government powerless to address future border crises. Judge Childs, you asked what the government could do to address this, and I think plaintiffs' answer was fairly candid, and the answer is nothing. I think plaintiffs' arguments are a dangerous invitation to return to the crisis that pervaded the southern border just 1 short year ago. Third, as to the class, I still have yet to hear any argument how this class definition is consistent with the Supreme Court's decision in TransUnion, a case that their brief strikingly does not address. And indeed, they seem to admit that the class could include people that may never come here. Such people do not have the sufficiently imminent injury to satisfy Article 3. They therefore do not have standing under TransUnion. They hence cannot be part of the class.
That's not really what TransUnion said. It talked about who could get relief, and nobody would be getting relief unless and until they were at the border, coming into the border, seeking asylum, subject to the proclamation and the guidance. So I think that it's a different situation. TransUnion was talking about people who might never be in a situation to need the relief. And here, the class definition only captures people who are, and once they are, in a position to actually need the relief.
Well, I think 2 responses to that, Your Honor. First of all, what the Supreme Court said in TransUnion, I think, is broader than that. It says Article 3 does not give federal courts the power to order relief to any uninjured plaintiff, class action or not.
Yeah.
So I think that
Order relief,
well,
not to include them in a class that might be eligible for relief if they actually stepped up into the situation of the class definition.
Well, beyond that, Your Honor, this is a B2 class. The remedy has to be indivisible. And so they are getting the same relief as everybody. If that relief is, so that is a formal matter, that relief is being provided to them, even though they don't have Article 3 standing. That's a fundamental nature of B2. And to the extent that the court might think the situation is different, that just means that a B2 class shouldn't have been certified at all.
And you had a 4th argument.
Yes, Your Honor. Certainly as to 1252 F1, we do believe that it certainly applies to asylum insofar as it applies to asylum in the expedited removal process. Expedited removal is absolutely one of the provisions that is covered under Section 1252 F1. And so to the extent that plaintiffs are arguing that the inability to get asylum and expedited removal is something that should be enjoined, which is something that the district court did do, that is squarely governed by 1252 F1 and the Supreme Court's decision in Aleman Gonzalez.
I can see
Go ahead.
where Wisha is arguably a binding precedent in a case that's in the same procedural posture. Was an appeal of a preliminary injunction. This is an appeal of a permanent injunction. So I'm not sure that, you tell me, I mean, and you represent the government, this will help you sometimes and hurt you sometimes. Is we should controlling precedent when the posture is an appeal of a permanent injunction?
I believe so, Your Honor, with the caveat that it's a published decision of this court. So to the extent that it resolves any questions of law, it's binding precedent of this court that would ordinarily be binding, subject to, various procedures like en banc or irons or intervening decisions.
I feel like that resolves whether a party is likely to succeed on the merits, but it doesn't actually resolve the legal question of whether the party is correct on the merits.
So I think that's the important caveat. So it is a published decision, so it's binding to the extent that the panel laid out a definitive position of law. And so to the extent the panel...
Wouldn't that be dicta if they laid out a definitive position of the law unnecessarily when they only had to reach whether there was a likelihood of success on the law?
I don't believe so, Your Honor. And as a practical matter, courts of appeals do it all the time. Certainly, many preliminary injunction appeals have questions of law. Those could be answered tentatively or definitively, and circuit courts routinely do the latter. We think there are many issues, and so there are certainly caveats in huesha, but there's also language that certainly appears to be the more sort of binding holding of law rather than a simple predictive judgment as to what party is likely to prevail, which makes sense. Consistent with it's a pure question of law. It's going to come back to you in the exact same posture in a preliminary or as a final judgment as it would as a preliminary injunction. But I guess even broader than that is, even to the extent that you don't think it's formally binding precedent, we think it's just plainly correct as a matter of law and logic, and we would urge this court to follow it.
I agree with that.
All right. Thank you. The case is submitted.
Thank you, Your Honors.
If the following report has returned Tuesday, November 4th, at 30.